Court does call the case of the people of the state of Michigan versus Jacqueline Jones, Washington.
Morning, Your Honor. Trevor Maybuck with you.
We're ready in that matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Ms. Jones Washington, who should be appearing by Zoom.
Yes.
Ms. Jones Washington, could you state your name for the record?
My name is Jacqueline Jones Washington.
All right. And you're requesting a forensic examination.
Yes, the court should have.
I have.
Okay, yes. So, Your Honor.
Well, the findings on it.
Yes.
Okay,
So today is the date and time for a competency review hearing. We have, has the court received the finding?
I have a one dated October 16th of
That's
25 that I've reviewed, finding her not competent to stand trial.
Defense has no further evidence to present.
Your Honor, the people would stipulate to the findings in the report dated 10/16/25 and have no additional evidence.
As I understand, they've indicated that she's not competent and is not restored.
That is our understanding as well.
That's correct, Your Honor, and I intend to file an alley in the case for the court today.
All right, very good. The court will make the finding that the defendant is not competent, is not restorable, and will not obtain competency within the statutory periods. I will sign the necessary orders in this case that the court has been provided and will await the knowledge.
Yeah.
Thank you. Thank you, ma'am. Court does call the case People versus Ardeen Henderson.
Assistant Prosecuting Attorney for People.
Your Honor, Alexis Plumai appearing with and on behalf of Ms. Henderson, who I believe is on Zoom.
Yes, she is, for the Wayne County Jail. Hello, Ms. Henderson. I don't know if somebody can unmute you. Are we trying?
We're trying, but I think she.
Oh,
Hello.
you did it.
Hello, Judge. Hello, I'm here.
Okay. Can you state your name for me?
My name is Ardeen Beatrice Henderson.
Thank you.
You're welcome.
All right, what are we doing?
Your Honor, at this time, Ms. Henderson would like to request a preliminary exam. Discovery is complete to my knowledge.
All right. And what date are we? 18. But I didn't know that we're going to do that. Ms. Henderson, how long do you anticipate being in the Wayne County Jail? Or do you have a release date?
Wayne County released me December 11th.
She has a sentencing date scheduled for the 13th of November in Wayne County. She also has an out-of-state hold.
All right. Well, I'm not gonna, could do the 25th, but unless there's an objection, I was gonna set it for December 2nd so that we could have time to arrange transport and the like. Is there any objection?
No objection.
All right. Preliminary examination will be in person. I'll set that December 2nd, 2025, 9 a.m. That is before Judge Perry.
Can I wear some regular clothes?
Pardon?
Can I wear regular clothes to court?
That is going to be up to, you need to speak with your attorney regarding that.
Yes, Ms.
Okay.
Henderson, I'll see if there's anything we can do prior to your exam date to get you a change of clothes.
Thank you, because their uniforms here doesn't fit me at all. Thank you.
All right. Bond will continue. Thank you, Ms. Anderson.
Okay, thank you.
Court calls the case People versus Colin Vanderbuet.
People.
Your Honor, Alexis Plumai appearing on behalf of Mr. Vandermeer, who I believe is also appearing via Zoom. Mr. Vandermeer, could you state your full name?
Colin Vandermeer.
Thank you. And Your Honor, our office is in receipt of the letter from the CFP. We would stipulate as to the finding and just request an adjourned probable cause conference date. I do have a green sheet and a finding in order.
All right. Any additional evidence from the people?
So, Your Honor, we'll stipulate to that finding and ask the court to sign the order as prepared by defense counsel.
All right. Court, upon reviewing the report, would find that at this time the defendant is competent to stand trial. Would specifically indicate that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent, and I have signed your order. I will set a probable cause. You want a couple weeks out?
Yes, please.
Is what? We're coming up on those weird timing.
So 2 weeks.
The 20th. Probable cause conference will be set for November 20th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you.
Thank you. Court calls the case, People versus Jeffrey Williams.
Ash yourselves for the people.
Okay. This is Ron Brown. Second row. I think it's going to be a waiver. Second row. It's going to be a waiver. I think.
Okay. Assistant Public Defender, Sniper Carey, I can rule, Your Honor, on behalf of Mr. Jeffrey Williams. I'm going to.
Okay. Oh, here it is.
Ron Brown, on behalf of Mr. Williams.
You all right? Yes, sir.
He's gonna waive it.
Mr. Williams, you're going to waive your right to have a preliminary examination? Yes, sir. All right. You understand that that's a hearing where the people would have to show by probable cause that the offenses alleged or committed and that you committed. Yes, sir. You understand you'll not have that hearing and you'll proceed to circuit court for further resolution. Yes, sir. People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on both counts. Mr. Brown.
Ron Brown, appearing on behalf of Mr. Williams, waive reading, standing, request adjourned, date, circuit court.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as both counts. Pretrial will be set for
November 19th at 1:30 with Judge Conlon.
November 19th, 2025, 1:30, Judge Conlon.
Bond continue.
Bond in this matter will continue.
Thank you.
Thank you.
I'll come to you.
Court calls case People versus Cortez Fairley.
Morning, Your Honor.
Sorry to wake you. No, go ahead.
Actually, I'm pretty much dozing off. Mr. Fairley? Judge, I was just appointed yesterday, so I'm not real familiar with Mr. Fairley. Is Mr. Fairley audience? Judge, I'm sure he's here, but he just doesn't want to respond,
Is
so
that right?
I would like to ask for a 2-week adjournment.
You would. Well, you've asked and denied.
You being a considerate judge,
Yes.
are.
Bench warrant will issue for defendant failure to appear. Bond will be set
Would you consider a show cause?
considerably in the amount of 10,000 cash shared. Excuse me?
No show cause?
You know what? Daddy, where's Daddy? He is? He may stay there. If people keep asking, warrant will issue immediately. Thank you.
Thank you for your consideration.
Court calls case People versus Dwight Miller.
Yeah, Mr. Miller, it's my understanding, Mr. Miller is, Mr. Miller, I don't know what you're showing us, but what, would you state your name for the record?
American State National. All my rights have been violated. They can't.
Did you
produce
state your
weapons.
name first?
American State National, man. Your Honor, I've been asking for the whole time, man. There ain't no firearm. There never was a firearm. I was kidnapped. My rights was violated. The lady lied on the scene. She said she called the police, said somebody pointed a firearm at her. Then when the police came on the scene, she made that statement again. And then it was proven, the cameras proved none of that happened.
If you want to try to overtalk me, you can. It's not going to work.
Dwight,
it's not the time for you to try to litigate your case.
Where's the firearm?
Dwight, just listen. I was just appointed yesterday. Mr. Gaddy gave me the discovery this morning. Why don't we ask for a 2-week adjournment and you and I can talk?
Where's the firearm? Where's the so-called person that's the victim that signed the sworn
Any
affidavit.
objection from the people?
No, Your Honor.
Probable cause conference will be
I
adjourned
object,
to
I object, I
November
object, I
20th.
object, I object. I don't get
Objections
consent.
noted and denied.
You violate
November
my
20th,
constitutional rights.
2025,
I
9
ain't about to
a.m.
write you up. I'm
Bond,
about to send up
bond
in
will
judicial
continue.
review.
And you know what? So
I'm about
let's
to
do
send
it this
judicial
way.
review.
That hearing will be in person. So if you got
My
something to
back
say, you
messed
can
up.
come right here and say,
My
in person.
back messed
Thank
up.
you.
You know
Mute
that.
him.
You know my back messed up.
You're welcome. Court does call the case of the people versus Jawante McFarland.
Good morning, Rob J. Cole on behalf of Mr. Farland. Judge, may we approach?
You are just having a bad day, aren't you? You are.
It's gonna get worse. It's gonna get worse. Judge Slade, can we approach very briefly?
Mr. McFarland, can you state your name, please, sir?
Yes, sir. Dejounte McFarland.
Thank you. Yes, you may approach. All right, record should reflect we've had a bench conference in this case. It's been a request for an adjournment in this matter. Court will adjourn probable cause without objection to December 11, 2025, 9 a.m. Bond will at this point continue. All right. Thank you.
Thank you, Your Honor.
sir.
You and staff have a great day.
You do the same. Court calls case of the people versus David Knight.
Good morning, Rob J. Cole on behalf of Mr. Knight.
Your name, sir?
Good morning, Your Honor. David Knight.
Thank you.
Judge, in this matter, we'd like to set an exam.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 8th.
Judge, I have a trial with Judge Kuhnke starting the 17th. Is it possible we can move this out? Or
I can set it the 18th. I can set it the 25th.
I know, but I can't be here on the 17th. I can, I'll have somebody cover for me. Wait, let's do it the 17th, Judge.
The 18th, you mean?
I'm sorry, the 18th, yes. And may I address bond when appropriate?
Yes, you may. Let me set preliminary examination in this matter will be set for November 18th, 2025, 9 a.m. That is before Judge. I don't think so.
Judge Washington.
That's before Judge Washington. All right. Chance to bond.
Judge, it's my understanding that my client is self-employed. He's a contractor. He unloads semis. He promises to appear for all future court hearings. He would ask that if the court does release him, if it has to be, he agrees to a tether. He's in neglect court regarding his daughter. He would like to attend those hearings in person, and he's not a flight risk. Again, he would agree to a tether. And he's posted bond on his other matter. So he's asking if the court would allow a PR bond in this matter.
Response.
I would object to any reduction in bond. In this case, he was present with the victim and their child, and pulled the victim up because he went through her phone and believed she was cheating on him. He then put his hand around her neck and strangled her, broke her phone, and was trying to prevent the victim from leaving the room with her child, or their child. I would object to any reduction in bond this time.
Was he on bond at the time of?
No,
Other matters
he
at
had
the time
posted
of this?
bond. I believe he had posted bond, right?
Yes, sir.
Well, right, but
I'm sorry,
but
yes.
he's on bond. He had just posted when this allegedly occurred. Is that right?
Yes, Your Honor. He disputes what the prosecutors, what they're stating. But yes.
Understood, but he'll have a preliminary examination to have that looked at. Motion for bond reduction, given those circumstances, is denied. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you. Thank you, sir. Court does call the case, People versus Thomas Gay.
Your Honor, we have both the people.
Good morning, Your Honor. Christina Sato for Thomas Gay, who's on my right. Mr. Gay, please state your name for the court.
Thomas Gay.
Requesting an adjournment.
Yes, Your Honor. I understand that there's a possible resolution. The prosecutor and I have spoken and possibly even resolve this before the next hearing.
Probable cause conference will then be adjourned to November 25th, 2025, 9 a.m. That's a Tuesday. Bond will continue.
Thank you.
Court calls case People versus Alicia Allen.
That's Phelps for the people.
Good morning, Your Honor.
Morning.
Assistant Public Defender Brian Bowling on behalf of Miss Allen. Can you state your name for the record?
I'm Alicia Allen.
Your Honor, we're asking that this matter be set for an exam. All discovery is complete to my knowledge.
And would the people have their witnesses available the 18th?
We can track my video.
Preliminary examination in person will be set for November 18th, 2025. 9 a.m. That is before Judge Moore.
Thank you, Your Honor.
Thank you. Bond continue.
Your Honor, may I address one issue of bond?
You may.
It's my understanding that the last time Miss Allen was before you, denied the request for her to be released to treatment. If it became available, I'd just ask you to reconsider that.
And Your Honor, I'm sure the court recalls when we were here before, I let the court know about my concerns, any change in her treatment, any change in her bond rather, at least the treatment, which is extremely unusual, but given the fact that this case, she was driving down 94, hitting more, I believe she hit at least one car, if not two cars, and this is an OWI third offense with a child as well in the vehicle, so I'm very concerned about her getting out of all this time.
And has treatment been arranged at all, or?
I don't believe so, Judge. There are other holds that she need to address as well. Just if it became available, we'd like to have her be able to have that opportunity to go into that program.
I mean, certainly if there were treatment available, I'm not going to have a problem. I mean, I have some issues. It's more the manner in which, I don't have a problem with the treatment. I have a problem with the manner in which she's released, making sure that we have enough safeguards and controls regarding her.
Okay.
So at this time, what I'll do is I'll again deny the request. But if you come up with something, certainly get it to the court and I'll be happy to take a look at it.
Will do. Thank you.
All right. Thank you.
Thank you, Your Honor.
Thank you. Court calls case People versus Larry Atkins. Or Larry. It's Larry. That's right. It's Larry. It's Larry that people messed up. I'm looking at it and I said, I know it's supposed to be. Man, I'm sorry. Go ahead.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Atkins. Will you state your name for the record?
Larry Atkins. Yes, I know. Okay.
Your Honor, we did finalize a mitigation report that's been provided to the people. They just need an opportunity to review that. Could have an adjournment.
Probable cause conference will be adjourned until November 25th, 2025, 9 a.m. That is a Tuesday.
Tuesday.
Bond will continue. Thank you.
Yeah. Okay.
Court does call the case People versus Robert Arnett. 3 cases.
Assistant Public Defender Sandra White on behalf of Robert Barnett.
Your name, sir? Robert Barnett.
And Your Honor, we were here before and we have identified that 2 of these cases are duplicates, so it's going to be only filed. I'll have the case number for you here in just a moment. I apologize for the delay. But other than that, I think we are ultimately looking at an adjournment for today's matters.
That is correct, Your Honor. We are asking for an adjournment on one of the cases, 25 F5 5793. We are still looking for media on that case.
On 5793.
Yes, we're still asking for body cams or any available videos.
Okay.
And the other one, I have two case numbers because I'm not sure which one is going to be dismissed.
Right. No, I got you. So, but you're ultimately looking for an adjournment on both of the ones that remain.
That's
Yeah.
correct, Your Honor. And if I may address bond,
Hang on one moment. Let me make sure my paperwork is right. So probable cause conference in this case will be adjourned to the 20th. November 20th, 2025 at 9 a.m. Bond will, well, yes, I'll address bond in a moment. I just want to get one that's going to be dismissed all set. Is it gonna really matter?
Ultimately, I think it's going to be the. Oh my gosh, hold on. I think it will end up being the 24FB1406.
That will be dismissed?
Yes.
Okay.
But I believe that one, it will be on the paper, but I do think it will be that case.
The 1406?
Yes.
Okay. And I'm assuming there's no objection to the dismissal?
No, Your Honor.
Right, so
No objection.
I'll mark that one as is. If there's some reason that's not it, then we'll deal with that. All right. And then the other case, I will adjourn to that same date of November 20th.
Thank you, Your Honor.
And then as to bound.
Yes, Your Honor, I do believe it was addressed at the last hearing, but Mr. Barnett wants this court to know that he will abide by all bond conditions. I believe one case is over a year old, and he was an addict at that time. He is currently doing Dawn Farms. He's doing it very successfully. He wishes to continue his treatment outside. If he cannot have a PR bond or home confinement tether, he wants to be released for treatment.
And I do think he was in bench warrant status at the time of the 2025 case.
Yes, he was.
That's my objection the last 5 years.
And that is my same objection. And he was a bench warrant status for a period in time. So I'm gonna, again, deny the request for a bond modification. In this matter, bond will continue. Thank you.
Will Your Honor consider release to treatment?
Pardon?
Will Your Honor consider release to treatment?
Certainly, I typically don't have an objection to somebody being released to treatment. So the only thing that you have to make sure, I would like a tether on that upon his release because of his failure to appear. And also that if he fails to complete the treatment, that he's returned immediately to the jail.
Absolutely.
All right.
Thank you. Your
Thank you.
Thank you. Court calls case People versus Emily Bates.
Assistant Prosecuting Attorney for the People.
Good morning, Your Honor. Kilma Dadish on behalf of Ms. Bates, who is on Zoom. Ms. Bates, can you unmute and state your name for the record?
Good morning, Your Honor. My name is Emily Bates.
Good morning.
Your Honor, we are asking for, I know I said one last adjournment last time.
You did.
We are
Wrote
incredibly,
it down.
yes,
And I knew you were not truthful.
but the prosecution have offered something even better. So we're just hoping to adjourn a
So
month.
you're blaming it on them?
No, I'm blaming myself completely.
It is my fault.
Always my fault.
Oh,
I'll take it.
taking the hit for you.
You get to choose.
How much more time did you need? To
4 weeks would be great, Your Honor.
4 weeks?
Yes, or 3 weeks. 4.
December 4th,
Thank you.
2025, 9 a.m.
Thank you, Your
Okay.
Thank you, Your Honor.
Thank you, ma'am. Take care. Bond continue. Court calls the case People versus Eduardo Benavides.
National Health for the People.
Mr. Benavides. Mr. Benavides, state your name for the record.
Thank you. Really, acting really?
Your Honor.
What?
We
No,
are.
it's okay. Sometimes there's
You know
just
what it
days
is?
that way.
I got this privacy screen on my computer. It's hard to see. I got to tilt it the right way. We're asking for an adjournment, Your Honor. We do not have a resolution yet for Mr. Benavides, but we're hopeful that we could get one. He does want us to address bond, Judge.
November 20th, 2025, 9 a.m. Without objection. Yes, that's the bond.
And Your Honor, we're asking that Mr. Benavides be given the opportunity to have a PR bond. I do know that there was an issue. He did miss his court dates. The court was, the court was kind enough to recall the bench warrant, but there was a bond issue relating to testing. I believe there were missed tests. There were 2 missed tests, and then obviously coupled.
That was after I had canceled his warrant. He then didn't test. Right?
I think that is right, Your Honor. I think I might have.
No, yeah, you had it right. I just want to make it very clear for the record.
Yeah, got it. So Judge, Mr. Benavides reports that he is currently employed. He had been working for the past 90 days before he lost his bond and was subsequently arrested. He reports that he has stable housing. He has family whom he lives with. He does now understand, Judge, the importance of not only coming to court. He has been very active with us in regards to his court dates. He lives in Clinton, Michigan, so he's not very, very local. So it is a bit of a distance. And I can't say that testing was not being done because he could not make it to community corrections, but I know he was having vehicle issues, which is what made him miss court. He knows now, Your Honor, that it's extremely important that he tests as directed by the court, as well as make sure that he communicates with us with any delays in regard to his upcoming hearing.
I don't need a response. Motion for bond reductions tonight. Under the circumstances, bond will continue. Thank you.
Thank you.
Court does call the case. People versus Winona Harvey.
Water Assistant Prosecuting Attorney to the people.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Harvey.
Harvey, can somebody unmute? Can you state your name for me?
Winona Harvey.
Thank you.
Yeah.
All right, what are we doing?
Your Honor, this is an adjourned competency hearing. I have had a chance to review the competency report. My office has gone over the report with Ms. Harvey. We do not object to the report.
She is still incompetent, but likely to obtain if she's provided treatment.
That is
she currently in her course of treatment regarding that? Or?
That I don't know, Your Honor. The report was not clear that I saw.
My impression, Your Honor, was that she's not. She's still
active.
Oh, she is still here. Yes.
She has not been. I don't think she's been found incompetent yet. I think that's what we need to do.
Yes, that's.
I thought this was a review. Hold on a second. I got the wrong one. Okay. All right. Any other additional information for the court?
None, Your Honor.
Your Honor, the people are in receipt of the report as well and have reviewed it. We have no objection to the court relying on competency.
This time, the court would find that the defendant is his current time incompetent to stand trial, but likely to obtain competence within the statutory period. And so when presented with the order, I will sign that, Mr. Gaddy. I will set a review competency hearing for, she's not out of there yet, so give me 90, we'll move it up if necessary.
Judge.
Set a review competency date for February 5th, 2026, 9 a.m. Yes, ma'am.
May I know today's date?
I'm sorry?
May I know what month this is? When I know what's going on? Can I know what's going on? May I know what's going on? Can I know what's going on?
All right, you come back to see me in February.
What month is this?
November.
Can I say, okay, all right.
That's what I'm gonna order. And your
Can I get
bond
some
will
paper?
continue.
Can I get a
We'll
paper?
see it.
Can I get a paper from
Pardon?
the front desk saying when I go to court?
Yeah, your attorney will give you one.
I'll send you a
Where's my-
notice, Miss Harvey.
No, I don't want to notice.
Okay, you won't miss it, trust me. All right, thank you.
The court with an order.
Yes. Court does call the case, People versus Anthony Campbell.
Special calls for the people.
Morning, Your Honor. Michael Gaddy, Assistant Public Defender for Mr. Campbell, who is here to my right. Your Honor, we're seeking a brief adjournment. Mr. Campbell has an assessment schedule with the 15th District Sobriety Court that may be informative of this matter as well. That assessment is scheduled, I believe.
Does he have a medical marijuana card?
You have a medical marijuana?
No. How do we know
He does not, Judge.
Mr. Allen?
Is there a bond violation report? May I approach?
Progress report, yes.
Your Honor, I thank you for letting me look at the bond form. Mr. Campbell is I believe he has a medical card that is expired. He reports he does have an appointment this afternoon.
He's also here on 2 charges of OWI with occupants under 16, so he really shouldn't be using any substance. But
Yes, Your Honor. I'd ask the court to give him an opportunity to continue testing, to abstain from marijuana, and allow the court to watch these numbers. To the extent that they are positive, continue to drift downwards until they hit 0, which may take a brief amount of I think sometimes up to a month to actually zero out if someone has in fact been using. But I'd ask him to allow him to continue to test and address that.
probable cause conference will be adjourned to November 20th, 2025, 9 a.m. This time, given the defendant's violations, his bond is revoked. No, my bail. Thank you.
Thank you. Your Honor, I didn't catch the adjourned date.
The 20th.
Thank you.
Court calls the case, People versus Nicholas Chalmers.
Trevor Maybell for the people.
Brian Bowling on behalf of Chalmers is approaching, Your Honor. State your name for the record, please.
Nicholas Chalmers.
Thank you.
Your Honor, I'm asking for an adjournment in this matter. Mr. Mayville and I are working to get a video issue ironed out, which I think we've resolved. We just need to get it over to my office.
Got it.
And then I'd like to address bond if I may.
Probable cause conference will be adjourned to November 20th, 2025, 9 a.m. Yes, as to bond.
Your Honor, my understanding, the current bond in this matter is a $10,000 bond that was set when Mr. Chalmers missed court back in early October. He's been in custody for 9 days since surrendering himself on that bench warrant. He does reside in Ypsilanti with his grandmother. His mother's here in the courtroom today to provide support to him. He does have a 5-year-old son, and he does work at FedEx. He's hoping that job will still be waiting for him when he leaves custody, whenever that is, hopefully today. I'd ask you to consider reinstating the personal bond that was originally set in this matter. If no objection to a tether, if you feel that that is appropriate.
Why did he miss this court date?
I got the days messed up. I'm sorry, Your Honor.
That sounds like a FedEx issue. You got the days messed up.
Yeah.
And he came back into custody because he turned himself
He
in.
did turn himself back in, Your Honor, to his credit. And like I said, he's been in custody for 9 days since then. I'd ask the court to give him another chance. This is the 4th PCC. To my knowledge, he had appeared for all prior ones prior to the one in October. And he's here today.
Yes, he is. Thank you, Mr. Bowman.
You're welcome, Judge.
Response on your people.
Under the circumstances, I'm not objecting, Your Honor. The defendant has a very limited criminal history. However, what is on there, though petty, is from out of county and shows failure to appears on both of those files as well in its past. So I just wanted to make a note that eventually the courts are going to start taking note of that, but no objection.
All right. I'll reinstate his previous bond, but he cannot be released without a GPS locating.
Wonderful.
Tracking.
Thank you, Your Honor.
You understand that, sir?
Yes, I do, Your Honor.
I'm just gonna tell you this. I'm doing this and I dare you not to show back up. Understood?
Understood.
All right. You do that.
Thank you.
Thank you.
Thanks, Judge.
Court calls case People versus Clinton Donald.
Assistant Public Defender Jay Bellinger on behalf of Mr. Donald. And
Your name, sir?
Clinton Donald.
Thank you.
Your Honor, this is another situation in which we unfortunately just have no discovery at this time, so I would ask for an adjournment.
Probable cause conference will be adjourned November 20th, 2025, 9 a.m. Bond continue.
Your Honor, if I may just quickly address bond.
You may.
Your Honor, my understanding is that the bond is currently set at $25,000. We are asking for a 10% provision on that. Ultimately, we are asking for a PR if the court would consider it. My client can stay with his mother in Belleville. He can willing to maintain no contact with the complaining witness who lives in Ypsilanti. So he has no reason to go to Ypsilanti. Otherwise, he is responsible for financially supporting 2 children at this time, and he's willing to do a strict home confinement and any other condition that the court feels is appropriate. We are just asking for a 10% provision, if nothing else.
Response.
Reduction in bond. In this case, the 15-year-old child of the victim called the police to say that the defendant was threatening his mom. When police came, the victim said she didn't know why they were there. Tried to get the 15-year-old to not speak to police, but he told police that the defendant trusted guns to his mom's head, and she and at that point the victim refused to let the child enter the house. So I have serious safety concerns. Should he be released, or does he be hearing information as well?
Anything else?
Nothing further.
Motion for bond reduction is denied. Bond will continue. Thank you.
Okay.
Court does call the case of People versus Jaqueline Cleaver.
People.
Honor, Assistant Public Defender Alexis Kumar appearing with and on behalf of Mr. Cleaver. Mr. Cleaver, could you say your full name?
Jaqueline Lavelle, please.
Thank you.
Say that first name.
Jaqueline.
Jaqueline. Okay.
Your Honor, I believe there should be a plea form in the.
There it is. The plea form indicates that the defendant would be pleading to an added count 4 of use of a controlled substance, a 1-year offense. Upon a successful plea to that charge, counts 1, 2, and 3 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
Yes, Your Honor.
May have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give to be the truth, nothing but the truth, so help you God?
Yes, sir.
State your name.
Jaqueline Lavelle Cleaver.
Sir, it is this court's understanding that you're going to plead guilty to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form today?
Yes, sir.
Any question about those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
Yes, sir.
Which one?
Probation.
All right. Were you on probation at the time of this offense?
Yes, I was already on. This was a couple years ago. I was already on probation. This case,
Just want to check something. All right. So you were on probation at the time of this offense?
yes, I was already.
All right.
No, I wasn't on it. I caught the case and then it was like PFI, pending further investigation.
Okay, so when this case was committed, were you on probation?
No, I wasn't.
for another-
No, I wasn't.
No? All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will,
Yes, sir.
and because you believe that you are indeed guilty of this offense, sir?
Yes, sir.
On the date of September 24th, 2024, location 2125 Glencoe Hills Drive, Pittsfield Township, Washtenaw County, State of Michigan. Did you have hydrocodone in your, or cocaine in your possession, sir?
Yes, sir.
All right. And did you know you had cocaine?
Yes, sir.
Had you used it?
Yes, sir.
All right. And you knew what you were using was cocaine. All right. Sir, if I accept your plea, I do have to advise you that if you commit misconduct as defined under the Michigan court rules between the time of my acceptance of your plea and the time of your sentencing, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be permitted to withdraw your plea. You understand that?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 4. Counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be December 10th, 2025, 9 a.m. That is before me. Bond will continue. All right, sir. Thank you. Sir, on your way out down the hallway, my probation department is on the left-hand side. Stop in there and just let them know that you'll need an appointment or whatever.
Okay.
Okay? Good. Thank you. Court does call the case, People versus Eric. Is it LZ Williams?
Overall, Assistant Prosecuting Attorney for the People.
Assistant Public Defender Sandra White on behalf of Eric LZ Williams.
Your name, sir?
Eric Cole, LZ Williams.
And I'm looking for my green sheep, and I am asking for an adjournment in this matter, Your Honor.
Probably the same pace in a second release there. Did you get, hang on, did you get him up to us?
I did.
She did? 2? She probably owes us 5. Probable cause conference in this matter will be adjourned to November 20th, 2025, 9 a.m.
Your Honor,
Bond,
may we address bond?
go ahead.
Thank you. We're asking for a home confinement tether. Mr. LZ Williams does have a job at Kind of Furniture where he works from 8 to 4:30. He has 4 kids. He will abide by all bond conditions. And with the bridge cars currently being cut off, his family is struggling. His criminal history consists of a driving while license suspended and operating while intoxicated. And these are his first felony allegations, although serious. At the time that they happened, he was very cooperative with the police. So we are again asking for a home confinement tether.
Response.
People would object. This has actually several operating while impaired, but the bigger concern is the allegations here. The allegations are that he fired off several shots either into the air or at a bush. There's some dispute as to where he fired them off. These occurred at his home, so I don't see how home confinement is going to protect the people who live there. I would ask that the people would object to any change of bond.
Anything else?
Would Your Honor consider
Do
lowering?
have a different address though.
We
in
could-
Wayne.
He can reside in Wayne, Your Honor.
The charges as I have them, I understand what the people just said was, but is that there was a discharge of a firearm toward a building or dwelling which was occupied
Or in.
or in the building. Got it. Motion for bond reduction, given the circumstances and seriousness of the case, is denied. Bond will continue. I think it's appropriately set. Thank you.
Thank you, Your Honor.
Court calls case People versus David DeLucia.
Counsel Water Assistant Prosecuting Attorney for the People.
Chief Public Defender on behalf of Mr. DeLucia. Today is the date and time set for the probable cause conference. I believe this is an adjournment request. Does the court have the green sheet?
I do not have it, but
I'm here. Thank you.
you're requesting an adjournment.
I am, and I want to address bond.
Your name, sir? David DeLucia. Thank you. All right. Probable cause conference will be adjourned November 20th, 2025, 9 a.m. Yes, as the bond.
Yes, Mr. DeLucia I'm sorry, Miss, I'm looking for the green sheet, but I'll do that in a second. Turned himself in when he got out of prison to handle this matter, a matter he wasn't allowed to handle in prison. He's always attended his court date. He has stable housing. He has a support system, his mother and father. He found out about other matters while in custody and he wishes to handle those matters. He's currently on disability, so he isn't working, but he wants to continue to get help while out of custody. He has shoulder surgery in April, and currently his shoulder is not in good condition. So we are asking for him to either have a PR bond or 10% on his current bond.
Response.
The allegation in this case is that he stole over $2,000 worth of jewelry, and then when he was approached by an officer outside, the officer told him to stop repeatedly. He repeatedly refused to do so. The officer then tased him, put him to the ground, and continued to resist. He tried to remove the barbs to his large size. The officer did not want to get into a physical altercation with him. Based on those allegations, people are concerned that he will not comply with these court's orders any more than he complied with the officers. And he did also just get off parole as constantly.
But he successfully completed parole?
He successfully completed parole, Your Honor, and probation.
But when did he complete parole?
March of this year.
So, and then within basically 6 months, this happens, or allegedly does.
It was a slip up, Your Honor.
Pardon?
It was a slip up, but well, allegedly a slip up. Thank you. Allegedly.
Well,
We're willing to.
that, I think if it causes a problem, I'm actually looking at his bond, given the release from parole and then the circumstances, at least as they're described by the people, I'm surprised that his bond is actually set as low as it is. But I'm not gonna raise it. I'll leave it where it is, but motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Thank you.
Court calls the case People versus Amiri Davis.
Assistant Prosecuting Attorney for the People.
Assistant Public Defender Jay Bell on behalf of Mr. Davis, who appears via Zoom. Mr. Davis, can you please state your name for the record?
Hello, Your Honor. My name is Amir Davis.
Amir. Okay.
And Your Honor, after speaking with the prosecution in this case, it sounds like we may be able to resolve with some misdemeanors. I was able to make contact with Miss Foster Tucker with regard to her scheduling in terms of keeping all these cases together if the court prefers to do that. I was not, however, able to get a hold of Mr. Quinn, so I don't know his schedule, but I don't know if the court.
I only have one case before me.
I understand there are co-defendants in this matter, Your Honor.
Oh, I
apologize.
Okay.
And those co-defendants are Mr. Davis's brother and an E. Williams. I don't know the first name. I'm sorry. I don't have that.
Earl Williams.
Earl, thank you.
All right. So you're looking, okay, gotcha.
Aaron Davis.
And my understanding is that Ms. Foster Tucker's plan is to adjourn this as well.
All right. Then I'll adjourn this to November 25th, 2025, 9 a.m. That's a Tuesday. And if the people could just let me know when the others are called up and we'll put them over to that same date. Bond will continue.
Thank you, Your Honor.
All right, thank you.
Thank you, Your Honor.
Court calls case People versus Brian Gerard.
Morning, Your Honor, Raymond Cook from People.
Your Honor, Alexis, my Assistant Public Defender appearing with on behalf of Mr. Gerard, who's approaching. Mr. Gerard, could you say your full name?
Brian Gerard.
Thank you.
Your Honor, I do have a green sheet here, as well as a stip in order to allow the treatment, if you would consider it. And we are just requesting a very brief adjournment, so that we can work out a resolution.
I don't have a problem releasing him to treatment, but he would need to be on a tether.
Understood. No objection to that, Your Honor.
Well, okay, good. So if I won't sign this order, if you could include that in the order to me, then
Yes, I
won't have
will
a problem.
update it.
All right. And you wanted an adjournment on this, so
Yes.
I'll adjourn probable cause to November 20th, 2025, 9 a.m. Bound will continue.
Your Honor, maybe briefly approach on this.
Fine. Went so well. Well, the record should reflect you've got a bench conference in this case. I will sign the order as you presented it, given the other circumstances of the other cases. I will also grant your request for adjournment.
Thank you, Your Honor.
I think we're done.
All right.
Otherwise, I have to listen to more of Miss Apple. Court calls the case People versus Gerald Dorsey.
Assistant Public Defender Hannah Apple, hearing on behalf of Mr. Dorsey, approaching now. Please state your name for the record.
Harold Dorsey.
All right. Thank you, sir. All right. What are we doing?
We have a resolution and.
Oh, I see.
Yeah.
Yeah, I have a plea form in front of me that indicates that the defendant will be pleading to count 2 of retail fraud second degree. The 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct.
Yes, sir.
May I have him sworn?
Right here. Do you solemnly swear to affirm the testimony you're about to give the whole truth and nothing but the true self you got? Yes. State your name. Harold Dorsey.
All right, sir. It is this court's understanding that you're going to plead guilty to the charge of retail fraud in the second degree.
Yes,
That is
sir.
a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that becomes the maximum fine. You understand that?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes. I thought it was this.
Pardon?
I thought it was, okay.
Yesterday, what could be the period without them.
Okay.
Okay. You understand that,
Yeah,
sir?
I understand. I just been going to this court, so I didn't know. She's just telling me about going to this new court.
Yeah, we're sick of you. No, all right. No, you understand Judge Valvo would be handling the
Yes, sir.
sentencing in this case, although I'm taking the plea. All right. Understanding all of that, do you still wish to plead guilty?
Yes, sir.
All right, to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
All right, you signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. You'll see a copy. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will,
Yes, sir.
and also because you believe that you are indeed guilty of this offense, sir?
Yes, sir.
On the date of March 4th, 2025, at the location of 254 Briarwood Circle, City of Ann Arbor, Washington County, State of Michigan, that being the Sunglass Hut, what did you do that makes you think that you're guilty?
Took a pair of glasses.
You did what?
Took a pair of glasses.
You took a pair of glasses and
Yes,
you
sir.
tried to walk out without paying for them?
Yes, sir.
All right. And the value of those,
I believe they were like $200.
was it in excess of $200?
It was about $207.
All right. And the store was open to the public at the time?
Yes, sir.
You didn't have anybody's permission to take that property?
No, sir.
And this property you took was property that was offered for sale by
Yes, sir.
them? Those ones that you put on the podium, those aren't the glasses, right?
Oh, no.
No, okay, I'm just,
No.
okay, I just thought I'd ask. I just thought I'd ask. Okay. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of your sentencing, if indeed you commit misconduct as defined under the Michigan court rules, you would not be entitled to any sentence evaluation and or recommendation, and the court would not be bound by that. And you would not be entitled to withdraw your plea. You understand that?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this?
None of the people are aware of it.
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied now.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be December 2nd, 2025, 9 a.m. That is before Judge Valwell. Okay. Bond will continue. Okay?
Thank you, Your Honor.
Court does call the case of the people versus Taiwan Griggs.
Kenneth Overwater, Assistant Prosecuting Attorney for Defendant.
Stephanie Hannah on behalf of Mr. Griggs. Mr. Griggs, would you please state your name for the record?
Taiwan Griggs, Grand Rising.
Hello, Mr. Griggs. She actually.
Taiwan Dominic Griggs.
Okay, sorry. Thank you, Your Honor. I have forwarded some mitigation information to the prosecutor in this case. I'm asking for
I guess it's up to preliminary exam.
we're going to set up for a preliminary exam, Your Honor.
Both of them?
Yes, Your Honor.
Is all discovery complete?
Yes, Your Honor.
People, other witnesses available the 18th.
I expect we shall.
Preliminary examination will be set November 18th, 2025, 9 a.m. before Judge Washington.
Your Honor, can we address bond? I do believe the last time we were here, the court was, or the prosecutor's office believed new charges were coming. It's my understanding those new charges have been brought to the court's attention in case 25 F5-5267. Anything else?
Say which ones?
I believe it's in 25 F5-5267 would be the new case.
Got it.
And Your Honor, as the court's aware, my client does have a substance abuse issue. You said you would consider it. I can prepare an order and I will prepare an order if the court is inclined to allow him to go to treatment.
I don't have a problem with that. Needs to include that there's a tether and that he will be returned to the jail if he doesn't complete.
Perfect, Your Honor. I'll get that to your honorable court.
So preliminary examination, the 18th, before Judge Washington. And bond will continue, and I'll sign that order when it comes.
Thank you, Your Honor.
Thank you. Court calls case, People versus Daryl Gardner.
Assistant Public Defender Hannah Apple. Mr. Gardner. State your name for the record.
Daryl Gardner.
Your Honor, Mr. Gardner is asking that this matter be set for a preliminary examination.
Did you want to deal with his violation first, or what is this?
I got this.
I signed in at the thing. Got the money to pay him, so he wouldn't let me test.
We have to get the money.
Okay, I'll get it. They got me scheduled to come up there Monday.
This coming Monday? Okay.
Mhm.
Your Honor, Mr. Gardner reports that he's scheduled to go back to community corrections for his intake and be able to pay for testing on
When?
Monday.
Yeah.
When is he scheduled to go back? Mr. Allen?
He reports that he is scheduled to go back on Monday.
When was that done?
When did you schedule that?
The day after I got out of jail, I went right up there.
Talked to her this morning, correct?
I think so. I talked to somebody this morning on the phone on the way here. I don't know who it was though.
Yeah, that's Agent Dozier, I believe.
Oh, yes, the agent, yep.
Did you schedule that with her today?
No, I scheduled it with the lady that I saw when I went up there. She scheduled it for some agent for Monday coming up.
Your Honor, as the report indicates, looks like he talked to Agent Dozier this morning regarding that. He reports that he's scheduled to report on Monday for
Why didn't he
testing.
go in before?
He
Well,
reports that he did.
His indications of what he said to community corrections are very disturbing to me. Because it's an absolute lack of cooperation.
They said you did not.
What made him supposedly call this morning? Because that would normally have been included in here. It's not included in here. And we received this communication regarding the violation at 9:32 this morning. So if he had an appointment, I'm sure they would have let us know. The witness is available the 18th.
Yes, sir.
Talked to Agent Dozier this morning.
I talked to somebody on, yes. I don't know their name. I was on the bus on my way here.
Your Honor, that's all the information that I have to present to the court is what's in the report. And he states that he had a phone call with Agent Dozier this morning regarding his
And
non-compliance.
he's telling me that he's set for an intake on Monday.
Yes.
Preliminary examination will be set for November 18th, 2025, 9 a.m. That's before Judge Moore. This time, what I have here is a violation. And at this point, you haven't been over to test at all since your release.
Yes, I did. They said
You haven't submitted a test.
I didn't. I tried. They wouldn't let me. They told me because I didn't have the money, they wouldn't test.
Bonds revoked, defendants remanded. If we find out additional information, then maybe I'll reconsider that.
Your Honor, I'll reach out to Agent Dozier just regarding that.
Court calls the case of the People versus Barack Howell.
Kind of the water, attorney with people.
Your Honor, Alexis Plumey, Assistant Public Defender, appearing with and on behalf of Mr. Howell, who is approaching. Mr. Howell, could you say your full name?
Hello, my name is Barrick Howell.
Thank you.
Hi.
Your Honor, I do have a green sheet to turn over. I am just requesting a brief adjournment. Weeks. Mr. Howell unfortunately was not accepted to mental health treatment court, so I am working on an alternate.
Alternate plan. All right. Without objection, probable cause conference. November 20th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you. Court calls case of the people versus Aaron Grable. It's your fault.
What? I wasn't even
No,
here.
I know. You should have been here to catch the cop.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Grable, who's here via Zoom, Your Honor.
Mr. Grable, can you state your name, please?
Aaron Grable.
All right, what are we doing?
Your Honor, I have submitted a green sheet. I'm asking to adjourn this matter 2 weeks. I have spoken with Mr. Overwater. I think a resolution is in sight. I'm going to provide some more information to him and let him follow up on that, but I think we're well on the way to resolving this.
November 25th, 2025, 9 a.m. Without objection, bond will continue. That's excused.
Thank you, Your Honor. I'll get you a call when I'm out of court, Mr. Grable, okay?
All right.
Thank you, Your
Okay.
Honor.
Court does call the cases of the people versus Dale Miller.
Ron Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Dale Miller, who approaches. Mr. Miller, when you're, please state your name for the record.
Dale Joseph Miller.
Honor, today's in date and time set for competency review. Is the court in receipt of the letter from?
Yes, I'm receipt from an October 24th submission to the court.
We have no further evidence to present to the court.
Your Honor, people have no further evidence and stipulate the use of that report and ask the court.
All right. This time, based upon the review of that report, the defendant would be deemed competent. Court will order so that the defendant now can understand the nature of these proceedings and the nature and objects of these proceedings and can rationally assist in defense. Therefore, the defendant is deemed competent.
Thank you, Honor. We will prepare orders to that effect.
Today.
Yes, we'll have top people on it.
Okay. And what would you like this set for next?
As soon as possible.
Okay.
Probable cause conference.
Probable cause conference. Set probable cause conference in this matter then for November 20th, 2025, 9 a.m.
November 20th. All right. Let's see.
Bond will continue.
Thanks. Thank you, Honor.
Thank you.
Yeah.
Court calls case People versus Alicia Cargill.
Morning, I'm Rob Tico on behalf of Ms. Cargill. Judge, this is a situation. This case has been going on since August. I've had several visits out at the prison with her. I don't think her earliest release date is till for another 9 years. I've sent her all the discovery. She was insistent on seeing the video. I had a visit set for 8 a.m. this morning. I was told by prison officials she no longer wants, she did not want to see me today. Speaking with her, I know she's objecting to the police report, which we went in detail. Can I just set an exam in this matter, Judge? And can we?
Well, I need her here to set an exam. They signed in, she would not come to the room. And then eventually the facility signed out.
What should we do?
Well, I'm going to adjourn it over. I mean, if she doesn't, then you have to figure out something if she doesn't want to participate, but I'm not going to just set it for an exam if the defendant's not participating or is not here.
Okay. Can we turn it out to the 20th?
Well, they're gonna have to do a new writ and they're gonna have to make sure that she's gonna actually participate in this. I'm not gonna have everybody go through work and her just decide she's gonna try to do it her way. So you'll have an opportunity to talk with her. I'll adjourn this at this point out to December 4th, 2025, 9 a.m. And that doesn't interfere with the defendant's release on anything, because she's not going anywhere.
Okay, all right, thank you.
Court calls case People versus Renee Hall.
Morning, Your Honor, bringing the cook to the people.
Brown String on behalf of witness call.
Your name, ma'am?
Renee Hall.
Thank you.
Did you get my green paper?
I did, Mr. Brown.
We're requesting.
Unlike
adjournment.
Shanaza, yours are right on time.
Thank you. We're requesting adjournment. The co-defendant is Mr. Gay, Thomas Gay. So you want to do the same date?
What date was that? 25th. Yeah, like that.
Thank you.
All right. Probable cause conference will be adjourned November 25th, 2025, 9 a.m. Bond will continue.
Thank
Thank
you.
you, Your Honor.
That is a Tuesday, by the way.
Oh, Your Honor.
No. What? What were you gonna ask? You were gonna ask to approach?
Yes, very briefly.
That never's the case with you, Brown. Come on.
Yes.
Thank you.
Thank you, Your Honor.
You're welcome. Court calls the case People versus Ryan Phelps. Two cases.
People.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Phelps, Your Honor, who's here to my right. State your name. Phelps?
Ryan Matthew Phelps.
Thank you. You're asking for an adjournment.
Yes, Your Honor, we're still trying to reach a global resolution in this matter. I have discussed the potential with Mr. Mayville of a potential release to treatment, and I will draft an order and submit it to Your Honor for review.
All right. Did you want me just to put, I mean, I normally put it out 2 weeks, but you're trying to get into a specialty court, and I know they're not operating that quickly, but I mean, I'll give you whatever date if you're trying to get in there.
Your Honor, if we can maybe set the 2-week date, and if need be, I'll adjourn it by stip and order or very early.
Probable cause conference, November 20th, 2025, 9 a.m. On continue.
Thank you, Your Honor.
Court calls case People versus Suzette Hampton.
Ash Phelps for people. Not to carry, I can really run. Yeah, half of Miss Suzette Hampton here. She was here. She was walking outside, said she needed to ease herself.
You told me that it was gonna get better.
I've got my green sheet. You see, I was back there
You got
talking to
green sheet,
Mr.
no
Brown.
client. Good.
I'm fighting for my life here, Judge. Can we just pass it? I told her that.
No, every Thursday I have to pass one for you. Why is that?
Oh, Judge.
No, you're not. I'll pass it.
Thank you so much, sir.
Court calls the case People versus Daniel Sims. Yes, he is. Unlike Miss Akinrule's time, we know where he is.
Client control, Judge.
Wow.
Not directed at me. Actually,
No, that was specifically directed at her.
no.
In fact, I heard the bus running over her. Mr. Brown, did you state your appearance?
Ron Brown appearing on behalf of my client.
Your name?
Daniel Sims.
Thank you.
You get my green paper?
I did.
Okay. Requesting adjournment, Charlie.
You didn't say the reason, but how much time did you need?
Can we get the November date?
Seriously?
Aren't you using the 25th?
Okay. There are three dates left in November.
Yes, sir.
So which
I didn't
one-
want to rush.
Do you want the 25th or the 20th?
We'd take the 20th.
The 20th?
Sure. Thank you.
Can I have the November date? Really? Probable cause conference will be adjourned November 20th, 2025, 9 AM. Bond will continue. Thank you, Mr. Sims.
Yeah, thank you.
Court calls case, People versus Robert Harris.
Trevor Maybell for the people.
Ron Brown appearing on behalf of Mr. Harris, Your Honor. We're requesting adjournment. And may I approach with an order signed, stipulated order signed by the prosecutor?
Your name, sir? Robert Harris. All right.
May we approach?
Yeah, what's the order? Is it treatment?
You're gonna want to see it, Judge.
Okay. Sure. Okay, and what I will do is, and I don't have a problem with that order, it's regarding those payments, it's just that, sir, you'll have to pay it downtown Ann Arbor at 15th District. Court.
Downtown.
Yeah, okay,
Thank you, Your Honor.
and I'll sign the order.
Okay,
That's where it needs to be paid.
understood.
All right.
With the holidays coming, Thanksgiving and Christmas, can you get like to the end of
I'm at least
January?
Past Halloween.
Well, trick or treat. He's asking for late January, so to
For what?
bring
For
some
a
more,
date?
bring some more money. Another installment.
I don't know what you're asking me to do. I mean, I'm
Adjourn
going to adjourn it out, but you want me to adjourn it in January?
Yeah, so he can raise some more money. If it's the holidays, Judge. He's got to eat, get presents.
No, I'm not doing January. I don't fall into what Brown asked for. What I'm gonna do is I'm gonna turn it to December 18th, 2025. Let's see where
A
we're at
week
at that
before
time.
Christmas.
What?
Thank you, Your Honor. Thank you. December 18th.
I'll put it on Christmas and just suit me and you.
Now, you know about the Grinch.
Thank you, Your Honor.
Thank you, Your Honor. I get that order to you.
Wow. Did you call me the Grinch?
No, I'm smarter than that.
Yeah, I heard it. That's what I'm hearing. Yeah, you better get out of here. Wow. I could be. Except my heart would not grow 3 times too big. Court does call the case of the People versus Dontrell Smith.
Cash calls for the people.
Mr. Smith?
Your name, sir?
Dontrell Smith.
Okay.
Your
Your
Honor,
request is
we're
gonna do-
asking for adjournment, yes, for AIM referrals and a moment to address bond, Your Honor.
If I do the 20th, will that give him enough time to
I would put it out further than that.
further than
Yes,
that?
please.
All right. probable cause conference, I will adjourn it into December 4th, 2025, 9 a.m. All right, as to bond.
Your Honor, we were going to be asking for a reduction in Mr. Smith's bond. Mr. Smith does have another case in 50th District Court, but I believe they're also going to be requesting
In which court?
15. It's just a misdemeanor there. It's an older case. Mr. Smith is from Fort Wayne, Indiana. He has family that lives there.
Can I, before you continue to go on, has he posted the other bonds?
No, I don't believe he has, Your Honor.
Is he going to be able to post those?
I believe they were waiting on this case to perhaps let him out for them to address bond, since this is the bigger deal case.
The only reason I'm asking that is because his bond is set at 1,000, 10%. And
I'd be asking.
it's like holding him. I mean, it's like they gave that bond just because he's incarcerated elsewhere.
On another case. Was it to convert to a personal recognizance bond, or was it just a low cash bond?
I wasn't there.
Okay.
I'm looking at the paperwork and it just says.
Okay.
Ms. Feltes, you wanted to say something?
Your Honor, my understanding is at the time of his arraignment on October 1st, we did request a $3,000 cash register bond with no 10% with flight risk concerns. The defendant home address is in Indiana, and he had cases and or warrants out of multiple states, Pennsylvania, Ohio, Indiana, New York, and Michigan. So we were concerned about
The whole rest belt.
Your Honor, in that case, we'd prefer to keep him in Washington on the low cash bond.
And again, I don't currently have the warrants or those cases, but that's my understanding is that on October 1st, that was our request for those reasons.
Oh. Anything else?
Nothing further, Your Honor.
Okay.
Thank you.
Motion for bond reduction is denied
Thank you.
in this case. Bond will continue. Thank you.
Your Honor.
I did. Court calls case of the people versus Carol Holland.
Assistant Public Defender Jay Bellinger on behalf of Ms. Holland who approaches, Your Honor.
Good morning, Your Honor.
Good morning, ma'am. I know, finally they like helped you with the door. Nobody was helping you. No, you two ought to be ashamed. All right. Your name, ma'am?
Carol Hollins.
Thank you. You're requesting an adjournment.
I am, Your Honor. Sounds like we may be able to resolve this with a misdemeanor eventually. I just need to collect some mitigation information. So I'm asking for 2 weeks. I think that would be sufficient to cover everything we need.
Probable cause conference will be November 25th, 2025, 9 a.m. That is a Tuesday.
Thank you, Your Honor.
Bond will continue. All right. Thank you, ma'am.
Thank you.
Okay.
Court calls the case, people versus.
Now I'm ready. Go for the lead.
Yep.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of Mr. Stamper. Sign.
Sir, state your name.
Jesse Stamper.
All right, what are we doing?
Your Honor, we do have a resolution. I've gone over his rights with him. I'm just having Mr. Stamper sign the sentencing judge waiver in the plea form. Fill that out. Yes, Your Honor. It's a guilty plea to a use, Judge. There is no sentencing or plea agreement. I have. And Mr. Stamper is currently on probation, but the probation, it's a little unusual. The probation predates this charge, but the date of this incident is before the probation, but I think you should be okay. I have gone over his rights with him.
Plea form indicates he's going to Lead to the charge of use of methamphetamine, the 1-year offense. Upon a successful plea to that charge, count. That's the court's full understanding.
That is our understanding as well, Your Honor.
Have,
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Jesse Saper.
sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court cost. You understand that?
Yes, sir.
You also understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 1482 District Court. You understand that?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
All right. You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
I'm on probation.
All right. Were you on probation at the time of this offense?
No.
All right. Has anybody promised you anything other than what's been stated here today to get you to plea?
No, sir.
Anybody threaten you or coerce you?
Nope.
You're doing this voluntarily
Yes, sir.
and of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense, sir?
Yes, sir.
On the date of July 4th, 2022, at the location of 724 North River Street, City of Ypsilanti, Washtenaw County, State of Michigan, did you have methamphetamines in your possession?
Yes, sir.
Had you used them?
Yes, sir.
Did you know what you were using was meth?
Yes.
All right. Sir, if I accept your plea, if between the time of my acceptance of your plea and the time of sentencing, you commit misconduct as defined by the Michigan court rules, you would not be entitled, nor would the court be bound by any sentence recommendation or evaluation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Judge.
And have I complied with the court rule?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be December 10th, 2025, 10 a.m. before Judge Barr.
Thank you, Your Honor.
Thank you. Bond continued. Court calls the case of the people versus Amanda James.
Trevor Maybell for the people.
Assistant Public Defender Hannah Apple standing in for Ms. Plumai on behalf of Ms. James. Your Honor, my understanding is that Ms. Plumai spoke with Ms. James earlier today. We understand that there's a current warrant out. She did turn herself into inpatient treatment. Unfortunately, we don't have verification of that. She reports that she's inpatient right now today, that she's in group. Oh, you're back. That she's in group treatment and that if allowed, she could appear from treatment at the 12:30 time block. That's what we
That's all
got.
correct.
When did she go into treatment?
She did not specify the exact date. She did send our office a message when we had reached out to her originally after the warrant was issued, and she stated that she was checking herself into inpatient treatment. We hadn't been able to get a hold of her since then, but she did send an email to our office this morning stating that she is in treatment. I responded to her and asked if she could potentially appear over Zoom to show the court that she is actually in inpatient treatment. She did respond to me just a little while ago and stated that she is in group until noon, but could appear anytime after.
Well, there's a current warrant that's still out because she's not presented herself to the court. So I'm gonna leave the no bond warrant out. I'm not setting another date for her. Somehow or another, she's gonna have to get herself before the court. Thank you.
Got it.
All right, court recalls the case, the people versus Cyrano Johnson.
Overwater Assistant Prosecuting Attorney for the people.
Good morning, Your Honor. Veronica Glenn.
Go ahead.
Should I request permission?
What?
Should I request permission again?
Didn't I already give you permission?
You did.
Did I? You know, you are too young to be forgetting things.
Oh, my God. Okay.
That's not you, Gary.
I forgot.
I've already, if I granted permission.
Thank you. Your Honor, I'm asking for an adjournment on behalf of my client, Mr. Johnson.
You have a green sheet or you gonna?
I do have a green sheet.
I will adjourn the probable cause hearing in this matter to December 4th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you.
Bond will continue. Mr. Johnson, how's it going?
So far, so good. Waiting
Huh?
on Thanksgiving.
What you say?
Good. So far, so good. Waiting on Thanksgiving. I do turkeys. So.
Oh, you do
December
turkeys?
4th. Yeah, that's good. So you won't interfere with none of that.
What, at the church you do?
I fry them. Yeah.
You fry them?
Fry turkeys for people.
I have to go find Mr. Johnson. No. All right.
Hit me up.
All right.
All right. Thank
You take care. Court does call the case, People versus Randolph Taylor. Okay, you know, sure.
Study the German, we study.
Oh, okay.
What is really going on?
Ms. Candace.
I will tell you, Your Honor, at this time, I am gonna ask for an adjournment of this matter. Late yesterday, we did get an offer and had already visited with my client. I want to convey that to him. He wants a 1-week adjournment to consider though, because he was ready to go to exam, is where the issue is coming
Got it.
in at. And I do have.
Sir, can you state your name?
Randolph Taylor.
Thank you.
Oh, sorry.
No, it's okay. You just started talking.
I
You do
did.
that.
I did.
You don't even let everything, you just start talking. I don't even know what you're talking about.
Yeah.
So they trying to tell me you told this me.
I'll give him the 1-week adjournment under those
Thank you.
circumstances.
You tell me they company from.
Yes.
Yeah.
Sorry, I didn't sign it, Your Honor. I'm
Oh, you-
sorry.
Oh, so it's half filled out.
It was 2/3.
No. I don't even know what this says.
It says, you
No.
are awesome. So,
Probable cause conference
Okay.
will be adjourned 1 week out to the 13th,
Thank you, Your Honor.
2025, 9 a.m. Bond continued. Thank you, sir. Court calls the case of the people versus Jermaine Johnson.
Trevor Mayfeld for the people.
Assistant Public Defender Sandra White on behalf and not with Jermaine Johnson. I have spoken to him this morning. He said
Did
he's,
you?
yes, several times.
How was he doing?
I was out there one time when you called my case.
So he was here?
No, I was on the phone. He's not doing too well. He said he's homesick and he was trying to get a ride.
Also
So,
has a bond violation.
yes, I did make him aware of that. So we are asking for an adjournment. I did do a green sheet.
That's okay. I don't need it. Bench warrant will issue for defendant's failure to appear. Bond is setting about $25,000 cash surety. That warrant will issue immediately. But
Why so high, Your Honor?
you want me to give me 50?
No, I'm good.
Okay, all right. Thank you. Why so high? You know, I don't remember what happened to the last attorney that asked me that. Haven't seen him since. Court calls the case, People versus Andrew Travis.
Prosecuting against the people.
No, we'll wait.
Public defender, not the kid. Did the prosecutor?
Yeah, he already did that like ages ago, waiting for you.
Sergeant Carey, I can rule Your Honor, on behalf of Mr. Andrew Travis. Mr. Travis, state your name for the record, please.
Andrew Jacob Travis,
Thank
Your
you,
Honor.
sir. I have before me a plea form that indicates that the defendant will be pleading guilty to an added count 2 of attempted resisting and obstructing the 1-year offense upon a successful plea. That charge count 1 would be dismissed. That's the court's full understanding of it.
Yes, Your Honor, that is what we have, Judge.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do. Andrew Jacob Travis.
All right, sir, it is this court's understanding you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court cost. Do you understand that?
Yes, I do, Your Honor.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in 1418 District Court. You understand that?
Understood.
So was plead guilty?
Yes, I do.
And to that charge, how do you plead?
I plead guilty, Your
Now,
Honor.
you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I understand.
All right, you signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, but I do have matters in Wayne County right now. But I'll be honest, Your Honor, I'm kind of fear for my safety in Wayne County. I just wanted to put that on the record, so I don't know if anything could change where I do more time in Washtenaw. Just wanted to put that on the record.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
No,
You're doing this voluntarily?
of my own free will.
Okay, involuntarily? Yes?
Yes, voluntarily.
Because you believe also that you're guilty of this offense?
Yes.
On the date of October 2nd, 2025, at the location of 128 North Normal Street, City of Ypsilanti, Washtenaw County, State of Michigan, did you come into contact with officers from the Ypsilanti Police Department?
Yes, I did.
What happened?
I resisted their arrest when they tried to detain me.
Okay, they were trying to arrest you?
Yes.
All right, and so they were performing their duties.
Yes.
And in what way did you resist them?
In what ways I wouldn't put my hands behind my back when they gave me a lawful order.
Okay, so they were telling you to do something and you just wouldn't do it.
Correct.
All right. It didn't work out well, I bet.
No.
Okay. Sir, if I accept your plea in this case, between the time of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be required to follow any sentence evaluation or recommendation in this case, and you would not be entitled to withdraw your plea. You understand that?
Understood, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Neither is defense, Judge.
Have I complied with the court?
Defense is satisfied as well, Your Honor.
All right, court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be
December 10th at 10 a.m.
December 10th, 2025, 10 a.m. before Judge Barr.
All right. Thank you, Your Honor.
Thank you. Bond will continue. Thank you, sir. Good luck to you.
Thank you so much, Judge.
Have a good one.
Court does call the case of the People versus Sandra Law.
Stephanie Cannon on behalf of Ms. Law. Ms. Law, could you please state your name for the record?
Sandra Law.
Miss Glenn.
I lost her.
You did.
I lost my intern, Your Honor, I'm sorry.
All right, what are we doing on Ms. Law's case?
Well, Your Honor, we are working on the case. She does have a bond violation. The court is
Yes.
well aware of it. We did receive, and I did provide the prosecutor.
Counsel
Or-
approach.
Yeah, you're welcome. Be right back.
We're back on the record in the law matter.
Yes, Your Honor.
What I'm gonna do is, we've had a bench conference in this case. I'm going to adjourn this out 1 week to November 13th, 2025 at 9 a.m. However, on September 25th, she tested positive for cocaine or other drugs, but my understanding is type medication. That's on September 25th. October 1st, she then tests positive for alcohol. So I have those two consecutive tests, or those two tests where she's got something in her system she's not supposed to have. And then I don't have another test from her.
Yes, Your Honor. I do understand that, and I will be providing the court with some medical records indicating that for a very good chunk of this, she was actually hospitalized. But my view of it, in truth and candor, is not indicated for all of it, but for a very good chunk of it, she was hospitalized. And Your Honor, I will do an order for inpatient treatment to see if that'll work for this court.
It may, but at this time, given what I'm seeing, I just put it over 1 week. You can get that information to me, but this time defendant's bond is revoked and it's remanded.
Thank you, Your Honor.
Recall is ready, Your Honor. That's your own.
Recalls case of the people versus, is that Hampton?
Cash fellas for the people.
Assistant Public Defender, tonight be here. Approve, Your Honor, on behalf of Suzette Hampton. Can you state your name for the record, please?
Suzette Hampton.
I knew you would show up. Everybody else had little faith in you. I said, Miss Hampton's gonna be here. I'll pass this matter.
I couldn't hold it any longer. I'm sorry.
What'd you say?
I couldn't hold it any longer. I'm
No, it's
sorry.
okay. It's okay. I knew you were here. I knew you'd come back.
That's right. Yes.
Everybody else didn't know. Everybody else thought you took off.
Oh, no.
But no, I had faith. All right.
Judge,
What
did
do we-
I get?
Okay, that's not how that really. But anyway,
We'd like an adjournment. Does the court
were you looking
have-
for your green sheet?
I was.
I already have it.
I thought
They
so.
called
I
the case
knew
and you
it.
gave it to us.
I did. Okay.
And
yeah.
it was shocking for you. How much time do you be looking for?
Judge, if we could get like a month, I mean, we're working on mitigation.
You're asking for a lot today. December 4th,
When you want to.
2025, 9 a.m.
Thank you, Your Honor.
Bond will continue. All right, thank you, Ms. Hampton.
Okay. Thank you so much, Your Honor.
You're welcome. Court calls the case, people versus Thomas Basher.
Cash fellas for the people.
Morning, Your Honor. Mike Getty, Assistant Public Defender on behalf of Mr. Vasher, who's here to my right. State your name, Mr. Vasher.
Thomas Basher. All right, thank you. Yes, sir. Question and adjournment.
Yes, Your Honor. And we are requesting a release of treatment. I did submit an order to that.
And if you submitted it, I would have signed it. Mr. Basher needs to get himself in. So I don't have a problem with that.
Thank you, Your Honor.
And you said there was a global resolution.
Yeah,
The other cases, how much time do you think you'll need to try to wrap up?
Maybe 3 weeks, Judge.
3 weeks. I'll give you the 25th or December 4th. Which would you prefer? It's like 2.5 weeks and
December 4th.
December 4th. Okay. Probable cause conference, December 4th, 2025, without objection. 9 a.m. Bond will continue. All right. Thank you, Mr. Vesha. I don't, Mr. Gaddy, I don't,
I can resend it if you like, Judge.
well, hold on. No, I did sign an order modifying, but I did.
Oh, thank you, Judge.
You're all set. Court calls the case, People versus John Logan.
I'm prosecuting on behalf of Sean Logan. Sir, please state your name.
Sean Logan.
Your Honor,
Yeah,
may I approach with the prosecutor?
well,
it-
what are we doing?
Well, he's waiving exam, but he also has a bond violation.
Yes, he does.
And he has a medical card that I wanted to share with the court also, and I wanted to share some other things with the court that I didn't really want to put on the record.
He's waiving his right to preliminary examination.
Yes, Your Honor.
Sir, is that correct?
Yes, sir.
You understand a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendant bound over to circuit court on count 1 with 2 following.
Ron Brown appearing on behalf of Sean Logan, waive reading, stand mute, request pretrial and circuit.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea to both counts. Pretrial will be set for
January 8th at 1:30, which that's what.
January 8th, 2026, 1:30. Judge Slay.
Thank you.
Thank you.
Thank you, sir.
Bond continue.
Thank you.
Court calls case People versus Sean Beater.
Ashley Feltus for the people.
Susan Bowles, so they're gonna happen.
Mr. Peter, will you state your name for the record?
I've been being sexually abused by certain guards at the jail, and I just want someone to know who can help prevent that from happening in the future. My name is Sean Veter. Wanted you to know because you're an authority figure who might be able to prevent such actions from happening against inmates.
Sir, you have a process. First of all, I do not believe you. And I'm just going to let you know that because I know many of these guards and many of these folks here.
Not all of
fine
them, just
people.
certain ones.
There's a process. If you believe that to be the case, there's a process through the jail by which you may make that complaint without trying to disparage the reputation of all of these fine officers.
It's not all of them, it's
Washington
just
County
a few of them.
Sheriff's
Most of them are good
Department.
people.
I'm done with it. I've told you to use the internal procedure. What are we doing on this today?
Your Honor, Mr. Veter wishes to waive his right to a preliminary exam.
Is that correct, Mr. Reader?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense is alleged
Same
was
guard.
committed and that you committed. You understand that?
What was that?
I'm sorry, Judge, I mentioned something to him.
What were you
regarding that,
saying?
if you could
I was
restate
trying to hear everyone at the same time.
You understand that a preliminary examination is a proceeding by which the people would have to show by the standard of probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand that waiving that, you will not have that hearing and that you'll proceed to circuit court for further resolution.
Correct.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of the information, waive his formal reading, and ask this matter to be set for a pretrial.
Defendant having waived formal reading, standing mute to the charge, court will enter a not guilty plea. Pretrial will be set for
November 17th at 1:30.
November 17th, 2025, 1:30 before Judge Hamud.
Speak the truth.
I understand. We'll talk with you about it. Thank you.
Bond will continue.
November 17th, Your Honor. Yes.
Yes.
Thank you, Your Honor.
Court calls case People versus Jack Saunders.
Ashley Feltus for the people.
Jack Sanders. I know you would have been right up here, but acting really was talking in your ear, wasn't she?
Hello, Judge. Ronica Glenn, appearing on behalf of Mr. Saunders. He is not present today.
He's not present.
No, so we are asking for an adjournment or at a minimum, a show cause.
Really? Did she tell you to ask for a show cause?
Yes,
Who did? Cannon said
Yes.
to ask him for a show cause?
she sure did.
So she was trying to set you up. That's okay. I got your back. Bench warrant will issue for defendant's failure to appear bond is set him at a $10,000 cash surety. That warrant will issue immediately.
Okay.
She did not hesitate not to protect Cannon. She sure did. Just set me right up.
Thank you, Judge.
What? Yeah. Court calls the case. People versus Procopio Vitale.
Trevor Mabel.
Mike Gandy, Assistant Public Defender, on behalf of Mr. Vitale, who's approaching.
Name, sir?
Procopio Vitale.
You're seeking an adjournment.
Yes, Your Honor. Mr. Vitale has been on the list to be assessed for Judge Kunke's sobriety court. I've been in touch with them. They're still, they're working through people. I don't know. They weren't particularly clear about how long I might seek, but I'd ask the court to maybe set it for 2 weeks out. I know he's been on the list for a long time. I did speak with them last week.
I remember a certain point. Okay.
Yeah.
Well, let's do this then. I've got 2.5 weeks. Let's go out to that and see exactly. Maybe we can get a handle on where we are. So it'll be November 25th, 2025, 9 a.m. All right. His bond will continue.
Thank you, Your Honor.
Hopefully they'll get to him. Has he even had has he had the beginning part of that?
I'm sorry?
Has he had the beginning part or?
I don't think they've been out to see him yet. Your Honor, if I will check with them, would the court consider a release to treatment if that would be a quicker route for him to get treatment?
Yeah, if you submit that order, certainly. I know that he's been waiting. It's like,
okay,
I've been seeing him so much, I was going to invite him to Thanksgiving. So, yeah, I mean, I don't have a problem releasing him.
Okay. I'll check and see which one will get him assessed first and
see if we can do it that way.
Thank you.
Thank you. Good luck. Just in, got it.
I'm sorry.
Oh, correct. Court does call the case of the people versus Matthew Wallace.
We just gotta get you.
Really?
Trevor Mabel for the people.
Assistant Public Defender, not on behalf of Mr. Matthew Wallace. Beat him up here, Judge. I got up here first.
No, it's pretty much like a blind squirrel finding a nut. It's gonna happen eventually.
Call it progress.
Faster than the broken clock.
Yeah, exactly.
You're right. You're right. Thank you, Judge. State your name for the record.
Matthew Wallace. Thank you. You're asking for an adjournment.
We are, Your Honor. We do, the people did make an offer to us. We've extended, we've relayed the offer to my client. So a short adjournment, Judge. We just need to get the paperwork over to the court.
Thanks.
You think a week and you'll?
I think a week would be
get through to
fine.
him and go?
Absolutely, Your Honor.
Then I'll adjourn these out 1 week to the 13th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. And we'll take Watkins whenever you're ready. They don't have.
Nope. He got picked up yesterday by somebody else, so.
So they lost a person? No, I'm kidding. Court does call the case of the Buell State of Michigan versus Robert Dwayne Watkins.
Trevor made up for the people.
Where is she? Come, geez, oh, Pete. No, you're getting like back and ruly.
I'm learning bad skills. Can my dad on behalf of Mr. Watkins?
Okay. No, they don't have him. He's been
Taken.
taken someplace else. So I don't know where he's.
I believe it should be Adrian that took him. I believe that's.
Are they gonna house him in Adrian then?
He has to get arraigned on a felony there.
Okay, so they might hold him there rather than bring him back. We
Yeah.
just don't know at this point.
Yeah.
And this was, if it makes a difference to the court or defense, this was projected to be a misdemeanor plea.
Got it.
So if we could have just a little bit of time, I can sort out where to do the writ, and maybe we can be ready to go.
You're on.
We'll give it a shot for the 25th,
Thank you, Your Honor.
November 25th, 2025, 9 a.m.
Thank you. Thank you, APM. Mabel.
His bond in this matter will continue. All right, thank you. Okay, folks, we would be beginning our 12:30 block right about now. We're gonna start just a little bit late, like probably 15, 20 minutes. I've got to give my staff a break. We thought we would have a break, but I'll give them a break because they were working while everything was down. So I want them to have some bit of respite. All right. So why don't we look at starting about 10-2 with the next block. All right, court's in recess.
All right.
Covered for the 25th or 20th?
I already did my order, but I can add it, I can do another one. You want? Alan.
Mr. Riddell, would you mind unmuting and speaking so that we can see if we can hear you?
So like, are you? Is that Jack?
No. Guardian, Miss Williams. Can anybody in Zoom start speaking so I can see if I can hear you or not? Mr. Daniel Simon, would you unmute and state your name?
Daniel Simon.
Thank you very much. I appreciate you, sir. Court will be in recess.
Okay.
Case people versus Javante Poplar.
Carolyn Foster Tucker on behalf of Javante Poplar.
Your name, sir? Javante Poplar. All right.
And Your Honor, we're just requesting an adjournment to review discovery. I'll get a green sheet. I apologize.
Okay. Just regarding discovery.
Yes, I'm just jumping into the case.
Probable cause conference will be adjourned to November 25th, 2025, 9 a.m. That's a Tuesday. Bond will continue.
Thank you, Your Honor.
Court calls case of the people versus Micah Williams.
Covered on behalf of Michael Williams, Ms. Williams, please state your name for the record.
Micah Williams.
All right, what are we doing?
Your Honor, today's, I was just appointed to this matter yesterday, so I am asking for a brief adjournment.
Probable cause conference will be adjourned to November 25th, 2025, Tuesday, 9 a.m. Bond continued.
Thank you, Judge.
Thank you. Court does call the case of the people versus Anthony Wilson.
Good morning, Your Honor, or good afternoon now, Your Honor. James 5490, on behalf of Mr. Wilson, who's present via Zoom. Please start your camera, unmute, and state your name for the record, Mr. Wilson.
Hello?
Mr.
you hear me?
Wilson,
You hear me? Okay, great.
State your name, sir.
Anthony Wilson.
All right. What are we doing in this case? I don't understand this.
Your Honor, if I could provide some clarity, there was a miscommunication between Mr. Wilson and I regarding my representation in this matter. And the miscommunication between myself and the courts came because this is a 14B matter that was transferred to your docket. So I do apologize for the inconvenience, but
14B matter that was transferred to my docket. No, this starts on my docket.
well, when I looked on this iChat, or excuse me, for the ROA, it was under 14B, not 14A1. Nevertheless, I think that's where the miscommunication came for the representation, and Mr. Wilson would like to proceed with the court-appointed counsel.
What? Well, it doesn't make any sense to me, counsel. I mean, I got a first thing that we received was, I think, an appearance, and then we get a stipulation. And then I think an email from you asking us to make sure that it gets to me to sign the stipulation. I signed the stipulation. And then next thing I know, I'm getting a order to withdraw as counsel and then a motion to withdraw as counsel on a stipulation. I signed a substitution I just signed that day.
And
counsel, the representation made has nothing to do with another court or anything else along those lines, but that there's been some breakdown in communication between yourself and the defendant.
What I'm saying is, prior to you signing the order, I reached out to 14A1, who told me that I was able to email to prevent the substitution being signed. I was unaware that the substitution had been signed already, but then when I called 14B, they said it had been signed. So that's where the miscommunication regarding the signatures and the substitution came. But the actual breakdowns between my client and I, for clarification.
Mr. Wilson?
Yeah.
Were you apprised of all of this?
Yeah, all of this is just too much for me as it is because I never even been in Washington County or whatever these locations are that's going on with this case. This matter is going on because I have a common name and I've been misidentified as I've been explaining to everyone. And he's just trying to get this over with, honestly.
Yeah,
So I need
but
to speak
who,
more.
Mr. Wilson, I'm not asking you about the incident itself. I'm just trying to figure out in terms of representation. Did you retain this attorney to represent you?
I'm going with the court-appointed lawyer, sir.
Pardon?
We had spoken. I was going to use them, but I can't at the moment. I'm going to go with the public defender.
Is this your case, Mr. Bowling?
It is, Judge. Yeah, Brian Bowling on behalf of Mr. Wilson, Your Honor. I was appointed to represent Mr. Wilson for today's hearing. And then upon receiving the assignment, I had learned that he had apparently had retained counsel, but that seems like that might not be the case. If he wants to go with the public defender's office, that's wonderful as far as I'm concerned, Your Honor. But once I learned that Mr. Wilson had retained counsel, I didn't have any further discussions about the case with him.
Right.
So,
I mean, everything stopped for you.
yes. So I would just, if he is going to proceed with
the defendant dropped, I gotta have him back before I do anything. I'm gonna pass the matter. Mr. Murray, this is not the way, not only in this county to practice, it is not the way to practice anywhere in this state to do this. This is craziness to me.
Understood.
I'll pass the matter. He's got to sign back on. Court calls case People versus Brandon Sims.
Ron Brown appearing on behalf of Mr. Sims. Your Honor, please introduce yourself.
Brandon Simmons.
Thank you.
Did you get the green sheet?
I did.
We're requesting adjournment.
Probable cause conference will be adjourned November 25th, 2025, 9 a.m.
Thank you.
Tuesday.
Thank you, Bond. Continue.
Thank you. Bond continue. Court calls the case People versus Tina McGarrah.
Order, Assistant Prosecuting Attorney for.
Assistant Public Defender Sandra White on behalf of Tina McGarrah, who's approaching the podium.
Hello, what's your name?
Tina McGarrah.
Thank you.
Hi, Miss McGarrah was to make a payment today. She does have the funds. She was on her way up to the counter and I told her to wait because I knew her case was going to be called. So she does have the funds that she was supposed to pay today. And then I believe she's to go further with an offer.
Once the payment's made and receive the receipt, then prepare a plea form, we can resolve it.
All right, she's gonna do that today.
Yes.
And everything. So let me put this out, and then you gotta get the paperwork. I'm gonna put it out to November 20th, 2025, 9 a.m. Bond continue.
Okay, you want the green form or? Thank you, Your Honor.
Court does call the case of the People versus Gregory Martindale.
Order, Assistant Prosecuting Attorney for the People.
Brian Bowling, Assistant Public Defender on behalf of Mr. Martindale. Gregory, state your name for the record, please.
Gregory Martindale.
Judge, we're asking for this matter to be set for an exam. I believe discovery to be complete.
People had their witnesses available the 18th.
My knowledge.
Preliminary examination in person will be set November 18th, 2025, 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
All right, thank you. Bond continue. Thank you, sir. Court calls the case of the People versus Mark Montgomery.
Ron Brown appearing on behalf of Mr. Montgomery, Your Honor.
Yes, sir, Mark Montgomery.
Thank you, sir.
Your Honor, I have a green sheet. Requesting adjournment.
Purpose.
Continued plea negotiations.
During this matter, November 25th, 2025, 9 a.m. Bond continue.
Thank you.
Hold on, you said what day?
The
November
25th. It's a Tuesday, sir.
Okay.
Thank you.
Yeah.
Court calls the case People versus Jessica Williams.
Special, I'm sorry.
Yes.
Jessica Williams.
Jess Williams. Did I start speaking French?
I think he's getting.
Court calls the case People State of Michigan versus Jessica Williams.
Good afternoon, Your Honor. Brady Cook with the People. Good afternoon, Your Honor. Justin Zayed, PA 1051 on behalf of Ms. Williams, present standing to my right. Ms. Williams, can you say your full name?
Jessica Camille Williams.
Thank you.
Your Honor, date and time set for the first PCC. We are respectfully requesting an adjournment to review discovery and for further negotiations. I've apprised my client of her rights with respect to waiving the 21-day rule. She's prepared to waive that.
Is that correct, ma'am?
Yes.
Probable cause, how much time did you need?
3 weeks, Your Honor. Pursuant to the.
I have the 26th or I have the 4th. Which would you prefer?
Would you prefer? Fourth, Your Honor, please.
That objection, probable cause conference will be adjourned December 4th, 2025, 9 a.m. Bond continue.
Thank you very much.
Thank you.
Your Honor.
Court calls case of the People versus Alexis Naveen.
People.
Alexis Plumai, Assistant Public Defender, appearing on behalf of Ms. Naveen, who I believe is on Zoom. Ms. Naveen, could you unmute and say your full name?
Alexis Alexander Naveen.
Hello, Ms. Naveen.
Hello, Your Honor.
I
How
have
are
a
you?
plea. I'm good. How are you doing?
I'm very well, thank you, Your Honor.
Good. I have a plea form. Is that what we're doing?
Yes, Your Honor.
All right. Plea form indicates that the defendant would be pleading no contest to 3 counts of attempted resisting, obstructing, and assaulting a police officer to 1-year offenses. Upon her successful pleas to those charges, counts 1, 2, and 3 would be dismissed. The one she's pleading to are counts 4, 5, and 6, if I didn't say so. The other agreement, there's a sentence agreement that the case would be transferred to the Veterans Treatment Court.
Yes.
That is correct, Your Honor.
That's the court's full understanding. Is that correct?
Yes, Your Honor.
Mr. Veen, if you could please raise your right hand, please. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you?
Yes, Your Honor.
All right. State your name again for the record, please.
Alexis Alexander Naveen.
All right. You can put your hand down. All right. Mr. Naveen, it's this court's understanding that you're going to be pleading no contest to 3 charges of attempted resisting and obstructing a police officer. Those are misdemeanors punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it. I have to make sure that you understand it. First of all, it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, Your Honor.
Second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced initially before Judge Valvo in the 15th District Court.
Yes, Your Honor.
All right. Basis for the no contest plea.
Lack of recollection, Your Honor.
All right. Still wish to plead no contest?
Yes, Your Honor.
All right. To the charge of attempted resisting and obstructing a police officer as contained in count 4, how do you plead?
No contest, Your Honor.
To the same charge as contained in count 5, how do you plead?
No contest, Your Honor.
To that same charge as contained in count 6, how do you plead?
No contest, Your Honor.
You understand that by pleading no contest, you will not have a trial of any kind.
Correct.
You signed an advice of rights form or had
Yes,
it
Your-
signed on your behalf. Is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
You understand that you're giving up all those rights, including your trial rights contained in paragraph 5 on that form.
Absolutely.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
All right. Are you on probation or parole?
I am on probation, Your Honor.
All right. You were not on probation at the time of this offense. Is that correct?
Correct.
All right. Has anybody, can you please mute Doris Williams? Has anybody promised you anything other than what's been stated here today to get you to plead to these charges?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
No, Your Honor.
You're doing this voluntarily and of your own free will.
Yes, Your Honor.
Court has been provided and has reviewed Ann Arbor Police Department report for their case number 24-23393.
Your Honor, if I may interrupt just for a moment, you said,
Yes,
has anybody promised me anything? I'm just gonna say that the Father has promised me that it will be okay. So I have to speak the truth.
Understood. All
Yes,
right.
sir.
All right. The court has received and has reviewed Ann Arbor Police Department report for their case number 24-23393. Any objections to the court reviewing that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Mr. Levine, I do have to advise you that if between the time that I accept your plea and the time of sentencing, that if you were to commit misconduct as defined under the Michigan court rules, that the court would no longer be bound by any sentence recommendation or evaluation, and you would not be entitled to withdraw your plea. You understand all of that, ma'am?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's pleas of no contest to counts 4, 5, and 6. Counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
December 2nd at 9 a.m.
December 2nd, 2025, 9 a.m. before Judge Valvo. Bond in this case will continue. I think, Ms. Naveen, that's finally come to a long road, right?
Yes, Your Honor. Yes, Your Honor. Can I just say thank you, definitely to yourself, for your mercy. It's been a rough road. So thank you for your kindness to me. Thank you to the prosecutors. Especially thank you to my lawyers, Alex Warren Green, Lauren Perrine, and Hannah Apple, and the public defender in Veterans Court. I can't remember her name right now. Lamise. So I just wanted to say I'm incredibly grateful.
Mr. Maine, I have to say this. I don't say this to many defendants. I am going to miss you. We've been going through this whole process, and it has been tough. And the hard part for me was I can remember the first time seeing you and meeting you, and then just watching things kind of, I'll just say, spiral.
Yes, sir.
But then you finding the fortitude, and you're right along with all of the people that have been involved in this, to kind of bring yourself back, get well.
Yes, sir.
And then there were times that you would appear on Zoom, and I could tell that day was a struggle, but you got here, you went through it. And then one of the great joys was then seeing you the next time, because you could just tell by either the smile or whatever that you were doing much better, and just to watch you progress. So I guess from my standpoint, thank you for teaching me a little bit about life, and I guess the whole thing of not giving up, right?
Yes, sir.
And you are absolutely correct in terms of all the attorneys, including the prosecutors in this case, and everybody taking an interest, of thanking them for what they've done. Every public defender that appeared on this case, and certainly Ms. Feltes and the other prosecutors, were all interested in trying to make sure that this was a success for you.
Yes, Your
All
Honor.
right. Yes. And I'll say on behalf of all of them and myself that while you thank us, we are all mindful of the fact that your service to this country, what you did and everything, we have to thank you, because we get to do what we get to do because of people like you. And
My
we're
honor.
always mindful of that. All
It's
right.
my honor. Yes, sir. If I may, just one more, there is a social worker. I cannot remember his name. He did the mitigation. He did a great job also. I just want to make sure I thank everyone.
All right.
On the
Well,
record.
sometimes when you do that, you'll leave somebody out, but I think everybody gets the point. It's all right. Okay.
Yes, Your Honor.
Ms. Levine, take care of yourself. God bless you. Wish you all of the best. And certainly with Judge Valvo over there in the Veterans Court, and whoever then takes over after her in that court, you're in good hands.
Yes, sir. And God has blessed me, and through you.
All right.
Thank you. Your
You
Honor.
take care.
All right. God bless.
Thank you.
You know something? I'm just going to say this because I'm all Washington County, all in. It is, for me, having sat here this long, one of the most fantastic things to hear a defendant not talk about one side or the other, not talk about one side or the other in a negative way, but talk about what cooperation there could be. and thank both the prosecution and defense and the court for how they proceeded in the case. I think everybody here in Washington County, although even if you weren't involved, needs to be proud of that, because that's Washington County, folks. Court does call the case of the people of the state of Michigan versus Aaron O'Rourke.
This is Public Defender Jay Donger on behalf of Mr. O'Rourke. Mr. O'Rourke, can you please state your name for the record?
Aaron O'Rourke.
And Your Honor, at this time, we were just seeking.
Everybody except Aaron. Go ahead. I had to do that. I tried to be nice.
I knew I didn't want to be.
can only go so far.
I knew I didn't want to go right after that case. I knew it. I knew it. Your Honor, we are just seeking to set this matter for preliminary examination at this time. My understanding is that discovery is complete, at least to the best of my knowledge.
All right. And with the people have their witnesses available on the 18th. All right. Preliminary examination in person will be set November 18th, 2025, 9 a.m. That's before Judge Moore.
Yep.
Bond will continue.
Thank you very much. Have a good rest of your day, Your Honor.
You're done?
I'm done.
All right. Take
You're
care.
welcome.
Court calls the case, People versus Andrew Patton.
Vote for the people.
Kadamadajish on behalf of Mr. Patton, who is approaching.
Your name, sir?
Andrew Spencer Patton.
All right. What are we doing?
Your Honor, we are asking for an adjournment. I did not have Mr. Patton's phone number. His phone had gotten stolen. I did get his advocate's phone number. They're working on getting him a new phone. We'd ask for an adjournment.
Advocate through what?
At Leaf.
Pardon?
Leaf Harm Reduction. Who is here in court with him?
Have you seen the violation report?
I have seen the violation report, and we can address it.
Yes.
Yes, okay. Mr. Patton is unhoused, Your Honor. He did not intend not to test. He simply cannot afford it. He did get in contact with Community Corrections today. I believe he spoke to Maya, who's his corrections officer. She advised him, as did I, to continue to be in contact with Community Corrections, even if he can't pay for it, because it's better than just not talking to them at all. Now that he has his advocate helping him, we have his advocate's phone number. I believe.
When was? Go ahead,
Yeah.
counsel. Mr. Allen.
Your Honor, we'd ask for an adjournment and for his bond not to be denied. It's a simple matter of not being able to afford the testing. He's told me that he's not using. He is doing an incredible amount of community service at this Leaf Harm Reduction. His advocate and him are working really hard on, getting him all the help he needs to get housing, to get his phone. He does have that support system, which I think is very important to get him moving forward.
How long has he been working with the LEAF program?
Go ahead.
For a couple months, so it's been hard being home.
Well, then I don't know. I mean, the reality of what I have sitting in front of me is that in the end of September, he tests positive for THC and cocaine.
Yes, sir.
And then I don't have another test. He's missed 6 consecutive tests. If you're trying to tell me, counsel, that the advocates are going to help him, and that may be the case, where were they at any given point during the last 6 test periods?
I mean, they sometimes lose contact with him because whenever, they get him a phone, his last phone that they got him was stolen because he needed the phone for the tether, for one of his tethers. His phone was stolen.
I got that already.
Get the copy, badge numbers.
Go ahead.
Yes. His phone was stolen. He lost contact with them. He was able to get back in contact with them. He's been volunteering there. It's hard, Your Honor, being on the streets, being able to, and I
get that, but the problem that I have is, had the testing been sporadic or had he been in touch with, then I can get that. But this is just,
May I speak, Your Honor?
Go ahead.
I have no source of income. Or no source to getting up there to pay for the test. Even if I pay for the test, I have no way of getting up there. It's catch-22. So if I pay for the test, I still, I can't afford the test. So if I can't afford the test, I'm still violating because I can't pay for it.
How'd you get the first test?
I had scrounged up some money panhandling, and that gets the law too. You asked me a question.
Is there anything from the people?
Your Honor, I'll add to the court's consideration that it was my intent to offer a reduction to use this, if this case involves a very small amount of controlled substance cocaine, and that is what he tested positive for. Bond was appropriate in this case, and unfortunately we rely on the bond conditions and the defendant's compliance with them for his safety and that of the community, and we'll defer to the court.
Anything else you want to say?
Nothing further, Your Honor.
I grant you the adjournment out 1 week to the 13th, 2025 at 9 a.m., but this is not an adequate. I get poverty, get all of that. But the thing is that even if when I have folks that can't afford to do it, they're at least in contact with community corrections. They're at least doing something, and I don't see any of that here. I see nothing. I see what really happened is he takes that first test as positive for 2 prohibited drugs and then doesn't show up.
You will be in contact with community corrections?
Yes, I've been talking to community corrections right after I left here this morning.
Well, yeah, once you realize you're in trouble, but what happened the past 6 weeks? I'm pretty much done. Bonds are revoked. We'll see him next week. Court calls the case, People versus Ramon Raymond.
Assistant Public Defender Sandra Light on behalf of Ramon Raymond. Your Honor, may
Take your hands out of your pockets.
I approach?
Yes. You're just seeking an adjournment.
Yes, Your Honor.
Is that right? Probable cause conference in this case will be adjourned November 25th, 2025, 9 a.m. Bond continue. All right. Thank you, sir.
Thank you, Your Honor.
Court calls case People versus Bridget Murray.
Order assistant prosecutor.
Assistant Public Defender, on behalf of Murray, who is approaching. Ms. Murray, state your name for the record, please.
Bridget Murray.
I have before me a plea form. Is that what we're doing?
That's correct, Your
The
Honor.
plea form indicates that the defendant will be pleading guilty to count 2 larceny less than $200, the 93-day offense. Upon their successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the. Is that correct, Ms.
Yes, Your Honor. Yes, Your Honor. Yes, Your Honor. I
Oh.
apologize.
Ma'am, if you could please raise your right hand.
I'm sorry.
What do you?
Me or her?
I'm used to Mr.
Well, you don't want me to do it?
You got it.
I'm qualified. Is that what you're saying?
I know,
I'm not qualified to administer an oath? What do you, really? Is that what you're telling me?
Overqualified.
You know what?
Overqualified.
Oh, I'm overqualified to administer. Isn't that something else? Mr. Becker, you want to administer the oaths? They say I can't. I'm kidding. Never mind. I know. I have to take my second ruling in. She's just out of control. Ma'am, if you could please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
State your name for the record.
Bridget Murray.
All right, Ms. Murray, it's this court's understanding that you are going to be pleading guilty to the charge of larceny less than $200. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that? All right. You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that?
Yes, I understand.
You get it?
Yeah.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
All right. And to the charge of larceny less than $200, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
I do.
All right. You signed an advice of rights form, is that correct?
Yes, sir.
Any questions regarding any of those rights?
Yes, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And because you believe that you are indeed guilty?
Yes, Your Honor.
All right, I'm gonna have to ask you to keep your voice up. You got a soft voice? No, you're good. July 9th, 2025, at the location of 2355 Jackson Avenue, City of Ann Arbor, Washington County, State of Michigan. What'd you do on that date that makes you think that you're guilty?
I took something that didn't belong to me.
All right, and where is this location?
In Ann Arbor, Walgreens.
At Walgreens?
Yes.
And you took a wallet that didn't belong to you?
Yes.
All right. And your intent was to permanently deprive the owner of either of that wallet or the contents?
To keep it, yes.
Yes? Okay. And I mean, you didn't have anybody's permission to take that?
No.
All right. And you're not the owner of that wallet nor any of its contents, is that correct? All right. Ma'am, if I do accept your plea, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would no longer, the court would no longer be bound by any sentence evaluation or recommendation. And you would not be entitled to set aside your plea. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
We're not yet.
And has the court complied with the court?
Defense is satisfied as well, Judge.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered through 15th District Court probation. Sentencing will be
December 5th at 8:30 a.m.
December 5th, 2025, 8:30 before Judge Perry. Bond in this matter will continue. All right.
Thank you so much, Your Honor.
Thank you, ma'am. Oh, I'm glad you're here now. I'm glad you're here, and so is Miss Akinruli. Because she told me I couldn't do some stuff. She told me I was unqualified to administer an oath. Yeah, I know, you should have seen the whole thing, and it was good Andy showed up. Andy stopped me from bringing her into custody.
I was very confused. I didn't know what I was walking.
It's just my courtroom. We never know what we're walking into. Thank you, Andy. Court calls the case, People versus Jesse Rogers.
That's adults for the people.
Yeah, the Assistant Public Defender on behalf of Ms. Rogers, who's way to the podium, Judge.
Your name?
Jesse Rogers.
All right. And you're looking for an adjournment of this, Mr. Gunn?
Yes, Your Honor. Ms. Rogers does have an appointment next Wednesday to discuss the matter with retained counsel.
You're seeking to retain someone else, ma'am?
I have not yet retained them yet, but I know who I'm retaining, and we just haven't met in person yet for this recent trial.
I'll give one more adjournment for the purpose. So.
Thank you.
Probable cause conference will be adjourned to November 25th, 2025, 9 a.m. That's a Tuesday. That's the only adjournment for that purpose, ma'am.
All right, I understand. Thank you, Your Honor.
Bond continued. Thank you. Court calls the case, People versus James Simmons.
Assistant Public Defender Sandra White on behalf of James Simmons. Mr. Simmons has been communicating with my office all week. He's been in the hospital. I did talk with him today. He did get released. He got released today. He had someone fax over the paperwork to my office. Must not have had the right fax number. He's going to have someone try again. He's insistent that he had it done. And
What?
that he had the paperwork faxed over and they're looking for it, but he's going to have it done again. So we're asking for an adjournment. He's been talking to us all week, Your Honor. So I'm asking for an adjournment.
You want me to adjourn it?
Yes.
Fine.
Thank you.
November 20th, 2025.
Did you want the green sheet?
Yes.
Thank
What,
you.
you were holding that? What? Waiting to see what I did?
No, of course not. Thank you, Your Honor.
Court calls the case, People versus Daniel Simon.
People. Brian Bowling, Assistant Public Defender on behalf of Mr. Simon, who hopefully should be on Zoom.
I am.
Oh, there he is. Okay. State your name, sir.
Daniel Simon.
Thank you.
I'm asking for an adjournment. Mr. Simon wants to come into the office and review discovery. So I need some time to do that.
All right. Probable cause conference then will be adjourned to November 25th, 2025, 9 a.m. Bond will continue, sir.
Thank you.
All right. Thank you.
Thanks, Jim.
Court does call the case of the People versus, is it Unite Singletary? I know I messed that up.
I don't think you did.
No, I know. No, I think I messed it up because she,
Your Honor,
when I
Alex,
said it the last time, she yelled at me. I
Your
remember,
Honor, Alexis Pluma, Assistant Public Defender with and on behalf of Ms. Singletary. And could you say your full name?
Unai Singletary.
I did. I knew I was right. All right, go ahead.
Your Honor, does the court have a copy of the plea form?
I do.
file? That is what we're doing today.
All right. Plea form indicates that she's going to be pleading guilty to a charge of disturbing the peace. They had a count to 90-day offense. Upon her successful plea to that charge, count one would be dismissed, and defendant's agreeing to forfeit any interest in a taser. And there is a sentence agreement between the prosecutor and defendant that the defendant will be sentenced under HIDA. That's the court's full understanding of the agreement.
Yes, Your Honor.
Yes, Your Honor.
May I have her sworn?
Right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, but the truth so help you God?
Yes.
State your name.
Unai Singletary.
Secretary, it's this court's understanding that you're going to plead guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days in jail and a $500 fine plus court costs.
Yes.
You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 14A2 District Court.
Yes.
All right. Understanding all of that, you still wish to plead guilty.
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on parole or probation?
Yes.
You are?
Your Honor, she was not on parole or probation at the time.
Time of this offense.
She was sentenced under HIDA in 14A2 yesterday on a different case.
Okay, all right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Has anybody threatened you or coerced you in any way?
No.
You're doing this voluntarily?
Yes.
of your own free will,
Yes.
and because you believe that you are indeed guilty of
Yes.
this offense. If I can find my other piece of my paperwork here. Really? Put it in order. Apologies for this. Where is my complaint? Should be back there. Is it right behind me? It should be on top of that. Yeah, I kind of. That's very strange. Yeah.
That's wrong.
Yeah, it's way wrong. All right, finally. December 12th, 2024, at the location of 421 Putnam Hall, EMU at Eastern Michigan University. What'd you do on that date that makes you?
Me and my friend were playing with a taser, activating it in the hallway, disturbing the peace of others in the hall.
Okay, and it disturbed the peace and repose of everybody around you by you doing that.
Yes.
All right. Ma'am, if I accept your plea, I do have to advise you that if you commit misconduct between the time of my acceptance of the plea and the time of sentencing, that any evaluation or recommendation the court would no longer be bound by, and you would not be entitled to withdraw your.
Okay.
Right?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
Have I complied with the court rule?
We're satisfied.
Defense is also satisfied.
Court will accept the defendant's plea of guilty to count one is dismissed. Pre-sentence investigation and report is ordered through 14A2 probation. Sentencing will be. Say again.
December 10th at 10 a.m.
December 10th, 2025, 10 a.m. That is before Judge Barr. Are you better than the last two times I saw you?
Yes.
Huh?
Yes.
You are?
Yes.
Did you get all of your questions answered?
Yes.
All right. Because you're going to be a nurse, right?
Yes.
Okay. Quit doing things like this. You hear me?
Yes.
All right. And I'm glad you got all your questions answered and everything. And I know you were just terrified, right?
Yes.
And your family knows about this?
Yes.
All right. Okay.
Thank you, Your Honor.
Thank you.
You're welcome. How are your grades?
All A's.
Hold up a minute. Hold on. No, that was too quick. That was way too quick. They are not all A's, are they? Are they? Go ahead. All A's? Congratulations. I knew there was, when I saw you on the screen, I knew there was something special about you. That's the kind of nurse I want, because I don't want nobody with a B. All right.
Thank you.
Young lady, you take care. That was like when my kids and I go, what are your grades? And they just go, oh, A's. I know that didn't happen. Yeah, it was too fast. He answered way too fast. Is that mom and dad?
Yes.
She got all A's? She does. She told you about her last two experiences here. Huh? And like, Dad, I bet you if she cried, you gave her anything, didn't you? Yes. I know. When she said, I just like, I don't know what to do. All right. Well, congratulations to you guys too, because it doesn't just happen by itself. All right. Take care.
Very good, sir.
Court calls the case, people of the state of Michigan versus Danielle Stewart.
I should call this for the people.
What, is he breaking furniture?
What? Yes,
You are?
yes, Your Honor. In a fit of rage,
Yeah.
State your name. Michael Gaddy, Assistant Public Defender for Ms. Stewart. State your name, Ms. Stewart.
Danielle Stewart.
Thank you. You're requesting an adjournment.
Yes, Your Honor. Just a brief adjournment. I think we'll be able to move this file at the next hearing. Ms. Feltus and I have had a chance to discuss it.
Probable cause conference, November. I'll just go to November 25th, 2025, 9 a.m.
Thank you.
Bond will
Excuse
continue.
me, can I speak?
Yes, ma'am. Can you
Hi.
speak? I don't know.
Hi.
Okay,
I was
go
just
ahead.
trying
What do you want to say?
I was trying to see as far as my phone goes because I need my phone, but they was telling me that I couldn't get it until it's done, but I've been adjourned 5 times. So I was just trying to see how I go about my phone.
Okay, I don't have your phone. Who has her phone?
I assume.
the police sees
Oh,
Seized it
please.
As part of the investigation, yes.
Yeah, it's gonna likely be held as evidence, ma'am, until such time as this case is resolved.
But I will call you when I'm out of court, Ms. Stewart, and let you know where we stand, okay?
Okay, thank you. You all have a good day.
Okay, you do the same, Mr.
Bye-bye.
Court calls the case, People versus Raymond Strausser.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Strausser, who should be appearing via Zoom. Your Honor, Mr. Strausser, he was previously, has been appearing via Zoom. He's been in treatment at the VA in Battle Creek. He was in person a couple times. We did speak with him yesterday and today. He was involved in an accident. He was hit on his bicycle and he was reportedly at the VA in Ann Arbor. I do have verification of that hospitalization, but he did inform me he'd at least be able to appear on
and
Zoom.
when Apple starts with their stories, it's like so hard to issue a warrant. Probable cause conference will be adjourned. November 25th, 2025, 9 a.m. I'll mark the file that defendant did fail to appear, but I do recall him being in the hospital.
Thank you, Judge.
That's the last one for today. Court calls the case of the People versus, is it Micah Van Bogert?
Brian Bowling on behalf of Mr. Van de Bogert. State your name for the record.
Makai Van de Bogart, sir.
Thank you.
Your Honor, I believe we have a resolution in this case. However, there's one issue with the collateral consequence that I want to verify. So I feel comfortable advising my client to accept the deal.
Okay.
So I just am asking for a brief adjournment.
Probable cause conference, November 20th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Danita Wade.
Brian Bowling on behalf of Ms. Wade.
Danita Wade.
Your Honor, I'm asking for an adjournment in this case as well. Ms. Feltus and I have been in contact. She is working on getting us some video discovery related to this case, so I just need some more time.
That is correct.
Probable cause conference, November 25th, 2025, 9 a.m.
Thank you.
Bond continue. Thank you, ma'am.
Give me one more.
Court calls case of the People versus Willie Wallace.
Thanks. Brian Bowling on behalf of Mr. Wallace. State your name for the record.
Willie Wallace.
Your Honor, I'm asking for an adjournment in this matter as well. I gave Mr. Wallace all of the discovery today at the courthouse. I want to give him an opportunity to review that independently.
All right. Probable cause conference, November 20th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Doris Ray Williams.
Assistant Public Defender Hannah Apple hearing on behalf of Ms. Williams. Should be appearing via Zoom.
She is. Ms. Williams, can you state your name, please?
Doris Williams.
All right, what are we doing on this?
You gotta, the court should be in. I have it right here. We have a resolution for her to plead guilty to an added count two. I apologize, Judge.
It is on you. They've done in his community, what mission and race.
I have a form that indicates that she's going to plead guilty to an added count to a retail fraud third degree, the 93-day offense. Upon her successful plea to that charge, count one would be dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor.
That's correct.
All right. Ma'am, Ms. Williams, can you raise your right hand to be sworn?
Yes.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, state your name for me.
Doris Williams.
Okay, you can put your hand down. Okay, ma'am, it is this court's understanding that you're going to plead guilty to the charge of retail fraud in the third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that becomes the maximum fine. You understand that?
Yes, sir.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court.
Yes, I understand.
All right. Still wish to plead guilty?
Yes, sir.
All right. And to the charge of retail fraud third degree, how do you plead?
Guilty.
All right. You understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You went over an advice of rights form with your attorney and they signed it on your behalf. Is that correct?
Exactly, yes.
All right. Do you have any questions regarding those rights?
No, sir.
All right. You understand that you're giving up those rights, especially your trial rights, which are contained in paragraph 5.
Yes, I do.
You understand you're giving up your right to appeal of right.
Yes, sir, I understand.
Okay. Are you on probation or parole?
No, sir.
All right. Has anybody promised you anything other than what's been stated today here on the record to get you to plead guilty to this charge?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense?
Yes, sir, I am.
Just crazy. Where? Okay. On the date of February 13, 2025, at 2020 Green Road, that being the bushes, what'd you do on that date that makes you think that you're guilty?
I put some medicines in my purse without paying and I left the store.
It was medicine?
Yes.
For you?
Yes.
Store was open to the public at the time?
Yes, it was.
All right. You didn't have anybody's permission to take those items, did you?
No.
And these items you took, they were items that Bush's was offering for sale?
Yes, sir.
Ma'am, I do have to advise you that when I accept your plea, if between the time of my acceptance of your plea and the time of sentencing, you were to commit misconduct as defined by the Michigan court rules, that the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, ma'am?
Understand.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
Defense is satisfied.
People are satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
December 2nd at 9 a.m. with Judge Bella.
December 2nd, 2025, 9 a.m. before Judge Valvo. Bond will continue. All right, ma'am.
Thank you, sir.
Thank you, Ms. Williams.
You have a good day.
You do the same.
Thank you.
Court calls the case, People versus Tierra Williams.
Good afternoon, Your Honor. Student Attorney Veronica Glenn on behalf of Tierra Williams. Can you state your name for the record, please?
Tierra Williams.
So is this case 3?
I think so. I think it is case 3.
Is that all you have?
That's all I have.
How come she didn't give you more?
That's a good question.
Really? Okay. Glad I'd asked. She's doing a fine job. You should let her flourish.
Hold on next week, Your Honor.
Oh, goodness. Thank you.
She's happy about that. All right. You're seeking an adjournment? Counsel?
Yeah.
Probable cause conference will be adjourned to November 25th, 2025, 9 a.m. That's a Tuesday. Bond will continue.
Thank you, Ron.
Okay, thank you. See. Court calls case of the People versus Damian Williamson.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Williamson. He is in the hallway with his minor child. We'll be approaching shortly. Jay went to grab him. He was just out there with his baby. Please state your name for the record, Mr. Williams.
Damian Williamson. Excuse
Jake.
me, sir. Thank you, sir. Sorry. Everybody doing?
Your Honor, we're asking for an adjournment for some continued plea negotiations in this case.
Adjourn the matter November 25th, 2025, 9 a.m. Bond continue.
Thank you, Judge.
Thank you.
Thank you. Court does call the case of the People versus JaVale Wilson.
On behalf of Mr. Wilson.
You're looking up on the screen, he was right behind you.
Just put back.
What's your name, sir?
JaVale Wilson.
Your Honor, we don't have discovery on this case. We are asking for an adjournment.
Your Honor, the defense is requesting discovery that we have not yet received.
Oh, you don't have it yet.
That's right. And so, I'm optimistic that we have it by the 20th, but if the 25th is.
Well, why don't I do this? Looking at the charge and everything. Probable cause conference will be adjourned December 4th, 2025, 9 a.m.
Thank you, Your Honor.
Make sure we get everything. All right, thank you, sir.
Thank you.
Bond continue.
Thank you, Your Honor.
Court calls the case of the People versus John Robinson.
Camera that is on behalf of Mr. Robinson, who is next to me. Can you please say your name for the record?
John Robinson.
Thank you. You're also requesting.
Yes, Your Honor. There is great offer on the record. We just need an adjournment for him to pay restitution.
Okay. How long is it going to take him to?
He can pay it tomorrow. He was going to pay it today. We were hoping for a resolution today, but he was not able to do so.
Okay, is he paying it through the court or directly to somebody?
I told him that if he pays it If he has someone pay it directly before Monday, we won't do it, but if by Monday he hasn't paid it, I'll submit the order.
But he's not gonna be trying to submit it to the court?
No.
Okay.
It's only $50 that's left.
It's important, 50. It's only 50. All right. Probable cause conference all adjourned to November 20th, 2025, 9 a.m. Bond continued. Thank you.
Your Honor.
Thank you, Your Honor.
No. And court recalls the case of the people versus Anthony Wilson.
Good afternoon again, Your Honor. For the people.
I'm here.
Good morning.
All right. You need to turn on your camera, sir.
Okay, no problem.
I really shouldn't, I'm just done talking about this because this makes no sense to me. I'm gonna grant, but not for the reasons as stated in the motion, because I don't believe them to be true. I'm gonna grant the motion for counsel to withdraw, but don't bring that garbage up in here again, counsel.
Apologize for the inconvenience to the court, Judge.
Sorry, Your Honor.
Go ahead. Your Honor, Brian Bowling for the Public Defender's Office on behalf of Mr. Wilson. May I approach?
Yes.
Your Honor, based on what was stated before, I really have not had any contact with Mr. Wilson, so I just asked for an adjourned probable cause date.
All right, Mr. Wilson, I'm gonna adjourn your case to the 25th, 2025, 9 a.m. That's a Tuesday, okay, sir?
Is there any way to make it any sooner?
Pardon?
Can we make
Well,
it
they've got to get all of your stuff. They've got to talk to you.
Okay.
So you can try to rush it if you want, but anybody that's rushed, court calls the case of the people versus, is it Matthew?
Yes, it's pronounced Matthew Capuano.
Exactly, Capuano.
And Your Honor, Joe Simon on behalf of Mr. Capuano. State your name, Matthew.
Yes, sir. My name is Matthew Capuano.
All right. You're also requesting an adjournment for me.
Yes, Your Honor, we're continuing to negotiate, but I think we're really close. I think the 20th will work.
Would work. Public cause conference, November 20th, 2025, 9 a.m. Bond continued. Thank you, sir.
Thank you.
Court calls case people versus Devon Watson.
Thorpe Water Assistant Prosecuting Attorney for the people.
Wade Henny, on behalf of Monica, appearing standing in for Monica Bajian, chair for Mr. Watson.
Your name, sir?
Davon Watson.
I have a plea form. Counsel, you can come out to the. And you're with the firm that he,
I'm standing in for Monica Bajian.
pardon?
I'm standing in for Monica Bajian.
Are you guys the same firm or no?
Yes.
Okay. All right. I have before me a plea form that indicates that the defendant will be pleading guilty to 2 charges. Count 2, a failure to stop after a collision, and count 4, attempted resisting and obstructing. The first one being a 90-day offense, the other being a year offense. Upon a successful plea to those charges, counts 1 and 3 would be dismissed. That is the court's full understanding.
That's correct, Your Honor.
Yes, Your Honor.
Is that correct?
Correct.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes. State your name. Davon Watson.
Sir, it is this court's understanding that you're going to plead to 2 misdemeanor charges. Is that your understanding?
Yeah.
The first charge is count 2, a failure to stop after a collision. That's a misdemeanor, punishable by up to 90 days, a $100 fine plus court costs. Do you understand that?
Yes.
And also count 4 of attempted resisting and obstructing a police officer. That's a misdemeanor, punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in this matter, and that you would be sentenced before Judge Washington in the 14B District Court.
Okay.
You understand that?
Yeah.
Understanding all of that, you still wish to plead guilty?
Yeah.
To the charge of failure to stop after a collision, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing a police officer, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct?
Yeah.
Any question regarding any of those rights?
Sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yeah.
You understand you're giving up your right to appeal of right.
Yeah.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
Doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you're guilty?
Yes, sir.
All right. May 26, 2025, at the location of South Harris near Russell Street in Ypsilanti Township, Washtenaw County, State of Michigan. Were you operating a motor vehicle?
Yes.
And while operating that motor vehicle, were you involved in a accident of some type?
Yeah.
What happened?
I was speeding fast and tried to park and sideswiped the parked car.
Okay. Did you report that accident to the nearest and most convenient police station?
No, sir.
Did you leave any identifying information such as name, insurance, or anything at the scene?
No, sir.
All right. And did you come into contact with police officers at some point?
Yes, sir.
What happened with that?
I tried to exit the vehicle.
Okay, back up. They pulled you over?
No. In the midst of me, the collision, I got out the car and tried to leave the scene while they was pulling up.
Oh, okay. So the accident happens, the police are pulling up behind you.
And I'm trying to leave.
And you got out of your car to leave?
Yeah.
Was it your car?
Yeah.
So.
Don't make sense. I know.
I know. Well, yeah. Okay, good. I'm glad you realized that. Like you're leaving this big, like heavy object that's got plates that go back to you there.
Definitely.
Right? Yeah, that didn't work out, did it? Okay. All right, sir. And you knew they wanted to talk to you because you had just been involved in the accident, right?
Yeah.
Okay. Sir, I have to advise you that after acceptance of your plea, if between that time and the time of your sentencing in this matter, you commit misconduct as defined under the Michigan court rules, the court would no longer be bound by any evaluation or recommendation, and you could not withdraw your plea. You understand that, sir? All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
I'm not.
All right. And have I complied with the court rule? Would it be proper to accept this?
People are satisfied, Your Honor.
Oh, all good.
All good?
I'm sorry, I correct you, yes, Your Honor.
All good. That's a legal term. Court will accept the defendant's plea to counts 2 and 4. Counts 1 and 3 are dismissed. Pre-sentence investigation and report is ordered at 14B District Court. Sentencing in this matter will be
December 18th at 10 a.m.
December 18th, 2025, 10 a.m. before Judge Washington. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case People versus Kirby Snyder.
Ashley Feltus for the people in both matters.
Good afternoon, Your Honor. Christina Costantino with and on behalf of Kirby Snyder. And Your Honor, I'm appearing in case number ending in 1426.
Michael Getty on behalf of Miss Assistant Public Defender on behalf of Ms. Snyder, 23F2415, Judge.
Ms. Snyder, can you unmute and state your name for the court?
Kirby Snyder.
Okay, thank you. All right, what are we doing?
Your Honor, with regards to my case, we would be asking to have this matter set for a preliminary examination. Discovery is complete to my knowledge.
That the 23 mattered for exam as well, Judge.
Both for exam.
Yes.
Discovery is complete on your matter, Mr. Chairman.
Your Honor, I think there was some video that I think no longer exists, so I think to the best of my knowledge, yes.
All right. People have their witnesses available the 18th.
We could try for that date, Your Honor.
Preliminary examination, November 18th, 2025, 9 a.m. That's, both of these are before Judge Moore.
Thank you, Your Honor.
Thank you, Judge.
Thank
Thank you,
you.
Judge.
Is that it?
Yes, that's all, Ms.
Okay.
Snyder.
Okay, thank you.
Thank you. Court calls the case,
Thank you,
People
Your Honor.
versus Nathaniel Bryce.
Dolph Lustig on behalf of Mr. Bryce. Good afternoon, Your Honor.
Good afternoon.
Judge, we're going to ask that this matter be set for PEC for an examination.
For a preliminary examination. Mr. Bryce, can you state your name, please?
Yes, Nathaniel Bryce.
Thank you. All discovery is complete, sir.
I believe it is. I've received the videos that I asked for and I have the reports.
The only thing that's missing, Your Honor, are medical records from the Michigan State Police trooper who was severely injured in this incident. I was able to make phone contact with her recently. However, I do not have her medical records yet. I understand that while she is off work, she should be able to testify, but I'm going to ask for a slightly longer setting to give time to get her scheduled to come in around any medical appointments she may have.
And Judge, may I inquire as to what days you hold examinations and whether they're during the so-called cattle call like today?
This is not a cattle call. This is a docket.
Okay.
But
are they on non-docket days?
Almost made it through the whole day without blowing a fuse.
I apologize.
We hold preliminary examinations on Tuesday afternoon, as we have for the past quarter century, with two judges holding those preliminary examinations simultaneously.
Well, what if I
And
want
if you
you?
want to call their docket, there are a number of them set before them. If you want to call their docket a cattle call, you may.
Fair enough. What Tuesday afternoon would suit, Madam Prosecutor?
I don't pick a date.
They don't pick a date. How far out did you need to get this done?
December, please, at least. Your Honor.
Pardon,
December.
sometime in December?
Yes, please.
I got it. Push. What's mine December? I don't? Yes, I got you. Yeah.
I'm sorry, the 23rd.
23rd?
Judge, actually the 23rd's fine.
Preliminary examination in person will be set December 23rd, 2025, 9 a.m. Is that at noon? At 12 noon. That's before me.
Excellent.
Bond will continue.
Thank you, Judge.
Thank you. Really? Really? Good, Ann. He says all week what you do is just organize the cows. Court calls the case, People State of Michigan versus Perry Malone Jr.
Trevor may vote for the people.
Moo, boo, moo.
So tempted to say moo.
I don't know why I'm usually a happy, jolly person. What? You know what? Come here and say that. Wait, you don't say it over a screen. No, go ahead. Okay, I'm sorry. Go ahead. Did everybody put their appearance on? I wasn't listening.
So tempted to moo. In fact, on behalf of all Perry Malone's present to my right.
Your name, sir?
Perry Malone.
Thank you. All right, you're asking for an adjournment.
Yes.
And how long did you need on that, Kenza?
2 or 3 weeks.
About 2 or 3 weeks. All right, why don't I do this? Probable cause conference will be adjourned December 4th, 2025, 9 a.m. Bond continue.
I'm sorry, did you say December 4th?
December 4th.
Okay, thank you. Court calls the case People versus Anastasia rates.
Trevor Mabel.
Morning, Your Honor. Please, well, good afternoon, good evening, whatever you call it. But Brandon Bird on behalf of Anastasia Rakes. Ms. Rakes, can you please state your full name for the record?
Anastasia Rakes.
You were at the beginning of my cattle call, and now you're here at the end.
Sometimes that's how it works. Sometimes.
Your Honor, we were here once before, and I believe discovery's been completed, but negotiations are ongoing and promising.
Okay. Okay.
Same here, Your Honor.
Probable cause conference. I think did we put your other one on the 25th, Miss? 20th or 25th? Did I give you?
Let me check.
I don't care. We're gonna see you both days anyway. But I'm trying to be nice. Completely against my nature.
Call me on guard. 20.
Well, if it's gonna take that long,
20th,
what?
20th.
20th? Okay, I'll put this one over to November 20th, 2025, 9 a.m. Bond continue.
Appreciate it. You all have a great day.
You do the same. Court calls the case People versus James Young.
Good afternoon. I'm Barton Morris, appearing with James Young.
Good afternoon. All right, you're requesting an adjournment.
Yes, Your Honor. We haven't received discovery yet.
That is correct, Your Honor. I don't know if the court called, but last time I indicated that there were about 6 million images that needed to be processed.
Yes.
Miraculously, that has been done and completed. Just waiting the reports. So
Okay.
should be 2 or 3 weeks should do it for us, Your Honor.
Well, and then you got to go through them, but let's do it this way. Probable cause conference, December 4th. Will that work for you, counsel?
Yes, Your Honor.
All right, December 4th, 2025, 9 a.m. Bond continue.
EIEIO.
Hmm?
The EIEIO.
Wow. Wow. You know, one more comment. I'm coming over to the bench. I'm gonna come over to the bench. I'll be in the jury box. I'll just be scrapping. I'm just, end of the day, you're pushing it. People versus Michael Lasser. Bond continue.
And good afternoon again, Your Honor. Robert Ullman with it on behalf of Mr. Laster, who is present over Zoom. Mr. Laster, can you please state your name for the record?
Michael Laster. I have a plea form. Is that what we're doing?
Yes, Your Honor.
All right, the plea form indicates that the defendant will be pleading guilty to an added count 2 of operating while intoxicated, second offense, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That is my understanding as well.
All right.
Mr. Laster, that's what you want to do today, correct?
Yes. All right. Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
State your name again for the record, please.
Michael Laster.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor punishable by up to 1 year incarceration, up to a $1,000 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes.
I'm sorry, I did not hear your response.
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court in this matter.
Yes, sir.
All right. Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes.
Do you have any questions regarding any of those rights?
No.
All right. Looking at paragraph 5, those are your rights which are part of a trial. You understand that you're giving up those rights as well as all the rights that are contained on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir. No, sir.
Anybody threaten you or coerce you in any way?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of this offense?
Yes, sir.
January 7th, 2025, at the location of I-94 near Harris Street, in Ypsilanti Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, sir.
Do you recall what you had and how much?
Well, it was a rum, spiced rum. And
Okay.
it was a couple glasses. I wasn't supposed to be
Okay.
leaving. Yeah.
Were you stopped by the police or was there an accident?
My tie rod broke when I was coming down the E-way.
Okay, and what happened after your tie rod broke? You went off the road?
I was trying to get over, and as I was getting over, I lost control of the car and it turned on its side. I'm not sure. I was knocked out at the time. My friend who was in the car with me actually is the one who brought me, who called me. When she called my name, that's when I came to.
Okay, but you do remember driving and you do remember at least the beginning parts of the accident.
I remember losing control of the car once. I was trying to get over. My arms were shaking, and
That was it. Okay. Okay, were you taken to the hospital, sir?
Yes, sir.
All right, and was there a blood test?
Yes, sir.
And what were the results of that blood test?
I actually don't remember. I think it was a 1 point.
We would stipulate to that, Your Honor.
All right, if I told you it was a 0.188, you have any reason to dispute those test results?
No, sir.
All right. And had you previously been convicted of either operating while impaired on or about August 16, 2002 in the 14A1 District Court, or operating while impaired on or about August, I think that is 16, 2022 in the 34th District Court?
Yes, sir.
Okay. Sir, if I accept your plea, if between the time of your plea and the time of sentencing, you commit misconduct as defined under the Michigan court rules, then what would occur is that the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, sir.
No, Your Honor.
And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 1 is dismissed. pre-sentence investigation and screening assessment is ordered at 14B District Court. Sentencing in this matter will be December 18th, 2025, 10 a.m. before Judge Washington. Bond with its conditions will continue. All right, thank you, Mr. Lester.
Well, you said December 18th?
Yes, December 18th. But follow the instructions of your attorney because you got to get in contact with 14B probation before that date.
I'll be in touch with you soon, Mr. Lester.
Okay, and, okay, yeah. I thought it was, yes. I wasn't aware of the year, but,
Okay, thank you, sir.
okay.
Thank you, Your Honor.
Court does call the case, People versus Martina Smith.
Good afternoon, Your Honor. Robert Ellman with and on behalf of Smith.
Martina Smith.
Thank you.
Your Honor, after having some conversations with Ms. Smith today, I am moving to withdraw as her counsel due to a breakdown in attorney-client relationship. This also comes at her request.
Is that correct, ma'am?
Yes, I feel that the attorney is not representing me fairly and is taking my life as a game. I just graduated college and
Mr. Alman,
yes, sir.
you have got to be kidding me.
If you hear what I hear, sir, and you wouldn't. Means to
Maybe, so you made that determination with your law degree. Oh, I'm sorry, do you have one?
I have a college degree, paralegal.
Yeah, but you don't have a law degree. I'm gonna tell you what, ma'am. This gentleman has been appearing before me since the day he started practice. And if you are coming before me and telling me that in meeting with you as a client, that he does not take you seriously, the jeopardy that you may be facing seriously, or do that, I'm gonna be honest with you, I do not believe you at all. That has never been the way that Mr. Ellman has conducted himself in this court. And quite frankly, is one of the finest attorneys Washtenaw County has. Now, he may have to tell you things you don't want to hear, but that's his job. And I've never known that man not to do his job. Were you? Didn't even make any sense.
Your Honor, my position is that if she has these concerns about me and my abilities, then we're not gonna move forward well together.
Hey, Mr. Ellman, I'm not gonna make you stay with somebody that can't appreciate your talents. I'm just not gonna do it. I mean, that's gonna be her business. Were you appointed on this case?
Yes, I was, Your Honor.
That means the PD had a conflict.
That's correct.
Which means it's gotta go back, which means that I'm gonna put this over, and for the time being, ma'am, guess what? You don't have an attorney. Because I'm letting you withdraw, and they're gonna have to get me an attorney, and you'll be notified as to who they are. So make sure you answer your phone. Probable cause conference will be adjourned. You are discharged from any further obligation.
Thank you, Your Honor.
Mr. Ellman. Probable cause will be adjourned to November 25th, 2025, 9 a.m. Bond will continue. Thank you.
Your Honor, that's it for me today, Your Honor, and thank you for those kind words.
Yep. Another happy customer. I didn't say anything. I don't know why you start crying. I said nothing. Court calls the case, People versus Try to Guide.
Trevor Mayville for the people, Your Honor. Your Honor, while we're waiting a second, I believe defense counsel is going to approach with a plea form and an advice of rights, in which case I'm going to have to make a quick amendment to it because.
The plea form?
Yes.
Well, and that's fine. And I'm just gonna tell you, we've got a problem.
We know what the problem is, Judge, so we'll address it, you know. Yes. Oh, thank you.
Okay. So that's the plea, but I'd like to address the bond issue first.
Okay. I mean, I know what it is. I've discussed it with my client, Judge, so I know.
Somebody want to explain? I've got a positive test for cocaine.
That's correct, Your Honor. Judge, it's not really, there's not really an explanation per se, Judge. I just would indicate to the court, she's dealing with a lot of health issues right now, Judge. I think again, she's prescribed the opiates. I know that's referenced in there, but she's got a cancer diagnosis, Your Honor, and I think that she has a appointment tomorrow, Judge, and she is enrolled in outpatient treatment, Judge. So I'm just gonna, if we're gonna take the plea today, Your Honor, I'm just gonna ask the court to maybe refer for a pre-sentence report, let her meet her requirements, and then we'll see, we can deal with all these issues at sentencing. I'm gonna propose that anyway.
So there's this option. I would note that this case is from back in early 2024, March of 2024. And the charged offense of possession of cocaine is the same controlled substance that the defendant is currently using. And that's concerning.
I thought we had, I want to make sure, I thought there was a previous violation.
There was, Your Honor, I believe it was for missed tests and not positive tests, but that's correct.
So she admits to the violation?
Yes, Your Honor, she did not have, other than, I mean, obviously they listed opiates. That's not, I don't think the court's concerned about that part, but.
I'm not concerned about the opiate part because at least there's an explanation that some of the.
I've discussed it with her, Your Honor, and obviously she's indicated a lot of pain, and I said that would address the opiates, probably not the cocaine. But she understands that, Judge, but again, she's enrolled in outpatient, Your Honor. Her next visit, her next appointment is Monday. She just got out of jail after being in there about 10 days, Your Honor, and I understand, and I've told her this could put her right back into jail. So she hasn't given me a whole lot to work with, Judge. I'm just asking the court to consider allowing her to come back for sentencing and, you know, let her do the outpatient and let her go to the oncologist tomorrow. Sorry.
And Mr. Burgess, I certainly understand that. The biggest problem that I have here though is that she was missing tests. She's here on a cocaine charge. She takes a test and cocaine's coming out. And
Judge, she knows she's facing, if the court accepts the plea today, she knows she's facing up to a year in the county, obviously, for the charge. So if she comes back with more tests, obviously that's more time. She knows the judge. So.
I'll hold on to the plea form, Mr. Allen, and we'll take her plea next week, and I'll make sure that at the time of taking her plea, she's clean, because I can't even guarantee right now she's clean. So I'm going to adjourn the probable, pardon?
I have a serious appointment with my pastor. I just found out the other day. I have an appointment tomorrow to see my specialist. It's a mass tumor. They're trying to see what they're going to do with it, if it's benign or it's full-blown cancer. I promise if you please today, I will not have no more dirties. I will not miss an appointment. I will not do anything. I will be.
Ma'am, you get picked up, arrested on a charge which involves the use of cocaine or possession of cocaine. You come here before me, we put you on testing. You don't do your testing initially.
I have forgot.
Then once we get you, I reinstated your bond previously. You get out and what do? You test dirty. I can't trust you.
Just told me-
Defendant's bond is revoked. Defendant's remanded. I'll return this
Your Honor,
matter
please,
to the
one more chance.
13th,
Please, Your Honor.
9 a.m.
Please, I gotta go, I get cancer, please, Your Honor, please. Please, I promise I won't give a drop, no more dirt, ever. I will do everything you want, please, please, Your Honor.
You said a week, Your Honor?
13th.
Please, Judge. I want to
Council approaching that.
Sure, Judge.